Good morning, ladies and gentlemen. Welcome to Hong Kong Legal Week 2024. The second legal forums on interconnectivity and development will commence shortly, so please be seated. So just a gentle reminder, please kindly turn your mobile phone into silent mode. The event will be conducted in Putonghua and English, with simultaneous interpretation in English, Cantonese, and Putonghua. So you can pick up a SI headset at the entrance of this hall. Please select Channel 1 for English, Channel 2 for Cantonese, and Channel 3 for Putonghua. And for online participants, please choose your preferred language by clicking the language button on the sidebar. 各位來賓，大家早晨，歡迎大家嚟到2024年度香港法律週第二屆融通與發展論壇即將開始，有請各位盡快就座。溫馨提示：請各位將你哋嘅手提電話調至靜音模式。咁今次嘅活動呢，將會以普通話同埋英語進行㗎，並且提供同聲傳譯服務。大家可以喺會場入口嗰度領取即時傳譯耳機，頻道1係英語，頻道2係粵語，頻道3係普通話。而線上嘅參加者亦都可以點擊直播畫面上面嘅語言按鈕，選擇你嘅語言。各位來賓，大家早安，歡迎大家莅臨2024年度香港法律週。第二屆融通與發展法治論壇即將開始，有請各位盡快入座，並把你們的手提電話調至靜音模式。本次的活動會以普通話和英語進行，並提供同聲傳譯服務。大家可以在會場的入口處領取同聲傳譯耳機。頻道1是英語，頻道2是粵語，頻道3是普通話。線上的觀眾也可以點擊直播畫面上的語言按鈕，選擇你的語言。謝謝大家。 Commissioner Choi, Secretary Lam, Mr. Liniot, Your Excellencies, Council General, distinguished guests, ladies and gentlemen, good morning. Welcome to the second Legal Forum on Interconnectivity and Development, an event of Hong Kong Legal Week 2024. This forum is co-organized by the Commissioner's Office of China Foreign Ministry in the Hong Kong Special Administrative Region and the Department of Justice of the Hong Kong SAR. Thank you very much for joining us here in person and joining us online. My name is Ivry Yao, and it is my absolute honor to serve as your MC for today. And now, ladies and gentlemen, to kick off today's forums, I would like to invite Mr. Cui Jianchun, Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR, to deliver his welcoming remarks. 我们掌声有请崔建春特。
Please welcome Commissioner Cui.
Secretary Paul Lam Dingguo, Mr. Alberto Nino, the General Counsel at the Asian Infrastructure Investment Bank, Honorable Counsel Generals, ladies and gentlemen, I'm very delighted to have this great opportunity to share with you about this very important topic, interconnectivity and development. I know that everybody, every society, every nation are focusing on development. And development is of the main theme for the international community. And President Xi Jinping proposed a great global development initiative in the year 2021. So I'm thinking that why the Chinese president has a proposal to the international community, we should start from 2013. That's the first time President Xi Jinping proposed the Belt Road Initiative in the year 2013, September and October in Kazakhstan and Indonesia. So today, I think this topic is related to every development of all the nation. In the year 2013, the essence of BRI, I hope that everybody could know that we have three principles. One is extensive consultation, and second is joint effort. The third is shared benefits. And also we have we call the 5 connectivities. The first is about policy coordination. Second is about infrastructure connectivity. And the third is about unimpeded trade and investment. And the fourth is financial integration. And the last one is people-to-people's exchange. So this 5 connectivity also is topic today. We are discussing about the interconnectivity. So I do believe today's topic is very important for Hong Kong, because Hong Kong can play a very, very important role for our integration or interaction or interconnectivity, because we believe Hong Kong should be and must be and will be dependent on mainland China and also the international community as well. So that means without the interdependence, nobody, no country, no society can make progress or make prosperous society. So this reason, I do believe that interconnectivity is of paramount importance for our development. So my colleague prepared I should read the text for everybody. So good morning. I'm very delighted to attend the second legal forum on interconnectivity and development. This is the second legal forum co-hosted by the Commissioner's Office, my office, and the Justice Department. I would like to express my gratitude to all the old and new friends for supporting this forum, and extend my warm welcome to all participants, both online and offline. I think that everybody admit that the world is undergoing unprecedented change. So today's keyword, change, change, and change, with the deepening multipolarity and economic globalization. I know that we're discussing about multipolar world and also the economic globalization. We are facing the great challenge. How can we build a new order? How can we build a new multipolarity and economic globalization? Countries are becoming increasingly independent. So some countries say, we should not depend on your effort and your contribution. But we know that without the interdependence of every nation, we not only to survive, I do believe there is no opportunity for thrive. So in today's world, connectivity is an unstoppable historical trend. Development is a common pursuit of the international community. I travel all over the world, especially Latin America, Africa, ASEAN countries. We do know what's the meaning of development, especially about material things. That means how can we work together? This is the reason why the common pursuit of the international community and the rule of law is a vital component of countries' competitiveness. I just share my thought with the Secretary for Justice. We think that the Hong Kong strength, the rule of law is strength of Hong Kong. Why? Because without the rule of law, without the awareness, without I think that the obedient to rule of law, we cannot only make a stable society, we cannot make a big deal for economic sector, the most important thing for the culture sectors. As a highly open ceremony that connects China with the world, Hong Kong possesses unique advantage that fit the globalization trend, but at the same time, face the task of leveraging legal means to safeguard development rights and expand the development space. We're discussing about the relationship between security and development. Here we believe that without the rule of law, we cannot achieve security. That means the security development is interrelated and also should be interconnected. In July this year, the third plenum of the 20th Central Committee of the Communist Party of China adopted a resolution which includes strategic arrangement for further reform and advancing Chinese modernization. Yesterday, I shared the basic idea about the resolution adopted by the third plenum of CPC 20th Central Committee. Today, I want to share you the big figure. I think that is important for everybody here. China now accounts for 18% of the globe GDP. That means U.S., I think, approximately 25%, so that we still have 7%, that's the gap. So now, and also the first figure of 18% of the total GDP, according for the global, we can say global global figure. The second is about China now, we contribute still 30% economic to the international community. That means China, Hong Kong is of very important, is paramount importance in economic sectors. I do believe that General Council, you have a lot of figures here. This is the reason why China matters a lot to the international community, not only because of the huge market. Most important, we have a very, not only the modern productivity, we are try to achieve the new quality productive force. That means the 18% and also 30% for the Chinese economy. And the most important thing that we believe the advancing China modernization and the strengthening rule of law is a key part of the resolution. How can Hong Kong capitalize on the rule of law to achieve new development. My answer is try to seize threefold opportunities. The first opportunity is from the improvement of Hong Kong's rule of law environment. The rule of law is a core value affirmed by the Basic Law and serves as a strong foundation of Hong Kong's long-term prosperity and stability. Article 23 legislation has been completed, and it better safeguards the rights of Hong Kong residents and Hong Kong's business environment and international exchanges. I want to share my observation. I work in Hong Kong just the past 6 months. So after passing the Article 23 legislation that's safeguarding national security ordinance, and some people say, oh, there's no change. There is no hindrance. There is no impairment for the Hong Kong's custom, Hong Kong's way of life. And I want to share with you, this is the truth. But we have to, people sometimes focus on the negative side. But I want to let you know, the national security law and also safeguarding Hong Kong national security ordinance not only change the way of life, it protects the way of life. When I talk to the Consul General's Chamber of Commerce, everybody recognize the security law, security ordinance, not only protect, not only the people's life, the property, promoting the business environment, and the most important thing that now we have a secured society, we have a stable society, paving the way for the way of life. So I think that this is very, very important now. We call it rule of law, that we have this true law is very fundamental for Hong Kong's long-term development. As safe, stable, and promising Hong Kong will continue to be a favored destination for investors from around the world. In these days, I discussed with the Chamber of Commerce, the chairman of the Chamber of Commerce. We know that it's high time for the business people to invest in Hong Kong, to invest in Greater Bay Area. I do believe business people can do good things for the people. Sometimes some politicians create chaos for the society, for the relations, geopolitics. I do believe that the rule of law in Hong Kong, the environment is good. It's good for everybody. It's good for every business. The second opportunity is from the great importance China attaches on the rule of law. So we know one country, two systems, one country first. Without one country, there's no two systems. So this is the reason why Hong Kong has great advantage, why international community, including diplomats, business people, and tourists, they believe Hong Kong, the great importance. We have the big, not only market, we have a big homeland, the mainland, to support Hong Kong, the development. So the rule of law is essential for Chinese modernization. China is now advancing both domestic and foreign-related legal frameworks, improving rule alignment in the Greater Bay Area, and cultivating legal professionals in international law. This will help enhance Hong Kong's legal expertise and invigorate its legal service sectors. I also want to highlight mainland China is counting on Hong Kong's rule of law. This is a foreign-related law. We are striving and try to build our nationals related the law, and Hong Kong really can do a lot for this development. The third opportunity is from the development of global governance. The rule of law is a core tenet for global governance. I do believe that we are facing the challenge of global governance. So every nation and try to, there is no copyright, and also there is no restriction for every country. How can we strive to get the national governance in the national context and national conditions. So under the one country, two system framework, Hong Kong enjoys a unique status to participate in international rule negotiations and multilateral mechanisms like the WTO. In the future, Hong Kong will play a more important role in improving global governance and will have more favorable external environment for development. I also want to share with you my understanding in the coming 5, 10, or 15 years. I do believe Hong Kong can do more contribution to the global governance, because here only Hong Kong as an internationalized city have one country, two system. I hope that everybody yesterday I shared with you know what's the meaning of free, know what's the meaning of independent, know what's the meaning of sovereign, know what the meaning autonomous. So Hong Kong, that if you understand the definition of these 4 English words, you really would understand what's the meaning of one country, two system. Ladies and gentlemen, strengthening the rule of law is crucial for China to pursue Chinese modernization. So in China, we have a very important emphasis. We will do that rule of law. We use a comprehensive rule of law. So it is crucial for Hong Kong to achieve new development here. I would like to share my suggestion, summarized as 3 C words. The first C word is competitiveness. Competitiveness. Hong Kong needs to reinforce competitiveness in the legal field and build itself into a preferred destination for global dispute resolution. Supported by national policies, Hong Kong is developing into an Asian-Pacific center for legal and dispute resolution service. The ALCO Hong Kong Regional Arbitration Center is the coming Hong Kong International Legal Talents Training Academy, which will be launched on this Friday. I think this is a very important institution. The international community, we discussed just now about how can we get more the legal persons, especially from the government, to come to Hong Kong, to let them know seeing is believing. I think that is not only good for Hong Kong, and it's good also for mainland and for international community. We believe that will further enhance Hong Kong's legal competitiveness. Recently, negotiations on the Convention for IO met that were successfully concluded in Hong Kong, and a signing ceremony is scheduled for next year. We will fully support Hong Kong in strengthening mediation services and help build Hong Kong into the capital of mediation. I also want to, at one point, the third avenue. One is litigations, second is arbitration. Hong Kong will provide the third avenue of vehicles for mediation, the International Organization for Mediation. And I do believe next year you will find Hong Kong's contribution to the international community. Now we have 19 member states have signed the convention of this very important international organization. And next year, I hope, and we will say the official operation of this organization. So here I thank you, the director of the preparatory office here. He has made a great contribution to make it a reality for this mediation. So that means litigation, arbitration, and the mediation will be the 3, but we have to recognize the mediation is complementary to the litigation and arbitration. Most disputes are solved by the litigation or the arbitration. So the second C word is connectivity. So we believe today's international community connectivity is of paramount importance. Hong Kong needs to improve connectivity of the rules and standards to support China's international opening up. We believe opening up is a secret is key of Chinese development. So in today's geopolitics, we cannot close the door. We have to open the door wider to the international community. You cannot say, okay, we will protect our society, protect our productivity by closing the door. Chinese has the reason to share with you that we, in the Qing dynasty, inefficient government and the corrupted government really closed the door. This is the reason we suffered more than 100 years humiliation by the big powers. So that means the open up is of not only the key of China. I think that is suitable to every nation. As a free port and separate customs territory, Hong Kong implements high standard trade rules and regulation, making it a testing ground for strengthening connectivity of cross-border legal frameworks between different law systems. So we are proud in Hong Kong we apply common law. People believe common law is in favor of business sectors. This year, a new service, trade management, was established between the mainland and Hong Kong. Looking ahead, we believe Hong Kong will fulfill its role as a super connector and also super value adder to strongly support China and Hong Kong's institutional opening up. The third C word is confidence. Hong Kong needs to boost the confidence in the rule of law to promote mutual learning between Chinese and Western or other nations' legal cultures. Hong Kong is a melting pot of Chinese and the international community, the legal traditions. Since Hong Kong's return, China's constitution and the Hong Kong basic law have formed the foundation of Hong Kong's common law system. Despite external, not only threat, sometimes coercion, and sometimes I hate to use words, the libel or slander, whatever, to Hong Kong's judiciary, to Hong Kong's independent judiciary and Hong Kong's judges. Hong Kong's legal system has demonstrated strong resilience. I do hope that people in Hong Kong and the international community, rule of law, independent judiciary, I said is not only the strength of Hong Kong, it is the strength of Hong Kong. Without the rule of law, I do believe the international community do not like investing in Hong Kong because investment should be predictable. Investment should be in the stable society. So we need stable society, and also we need democracy. So we will support Hong Kong in an expanding international legal exchange and telling the rule of law stories of the country and Hong Kong to the world. I want especially thank to the Chairman of Chamber of Commerce from UK, from US, European Union, ASEAN countries. I do believe that your decision in Hong Kong is right. This is not only for your business, not only for profit. Hong Kong needs your benefit. Mainland needs your investment. And I do believe in today's situation, business people play a very important role because some politicians is not fighting for the national interest. They are fighting for the personal party, group interest. So this is the reason we should commend the contribution of business people in Hong Kong. Ladies and gentlemen, Hong Kong stands at a critical juncture for new opportunity. It must further leverage its unique strengths in rule of law to seek greater development. The Commissioner's Office is ready and willing to work with all of you to help Hong Kong achieve new success and also make new contribution to national development. In conclusion, I want to thank you again for this very important forum, Interconnectivity for Development to Development. I wish this forum a great success. I thank you all for your kind patience and attention. Thank you.
Thank you very much, Mr. Choi. Please remain on stage. Please remain on stage. And please kindly proceed to the center of the stage first. 好，也请崔先生可以移步到舞台中间的位置。Thank you very much for your kind remarks. 那么马上会进行合影的环。
Okay, time for group discussion. Now, may I invite Mr. Paul Lam, Secretary for Justice of the Hong Kong SAR. Now, may I invite Deputy Commissioner Fang Jianming of the Commissioner's Office of the Ministry of Foreign Affairs of the People's Republic of China to the Hong Kong SAR. Mr. Horace Chung, Deputy Secretary for Justice of the Hong Kong SAR Government. And may I invite Mr. Alberto Linio, General Counsel of the Asian Infrastructure Investment Bank. And may I invite Dr. Sun Jing, Director General of the International Organization for Mediation Preparation Office. And also Dr. James Ding, the Law Officer of the Department of Justice of the Hong Kong SAR. And may I invite all the moderators and panelists of the legal forum today to join us on the stage for the group photo.
Our VIPs on stage for a group photos. Should we all give a big round of applause to our moderator and speakers as they're going to enlighten us with their insight and a lot of knowledge today. Welcome you all. So let's make sure all of our guests is already on stage. So let's stand slightly closer with each other. 请大家再一次站得再靠近一点，然后看一下中间那位摄影师，再来一张合影。请大家保持笑容。Alright, so please kindly stay for our media friends as well. Okay, so please kindly stay for one more photos. And also our videos as well. All right, a big round of applause for our guests on stage. Thank you very much. So please kindly be seated off stage. Thank you very much. Thank you very much for supporting our event today, sharing with us your insight and a lot of important information and knowledge. Thank you very much. So today we have prepared fruitful programs for all of our audience here who are joining us here in person and those who are joining us online. So later we're going to have our keynote remarks by our esteemed speakers. So he's going to talk about promoting good governance and high quality development under international law. And now, ladies and gentlemen, without any further ado, let's welcome Mr. Alberto Linio, the General Counsel of the AIIB, to come up on stage to deliver his keynote remark. Let's welcome Mr. Linio.
Good morning. Good morning, Honorable Commissioner Cui Jianshun. Good morning, Honorable Secretary of Justice for Hong Kong, Paul Lam. Good morning, ladies and gentlemen. First of all, I want to thank you very much for the kind invitation for me to be here again since yesterday. And I was just joking a little bit with Commissioner Cui Jianshun that he set the bar very high because he already said everything that I wanted to say, especially because at AIIB, the Asian Infrastructure Investment Bank, we have three pillars. The first pillar is green finance. The second pillar is connectivity with Asia and within Asia. And the third pillar is the development of private sector. So Hong Kong is simply the best place for us to talk about high quality development. So I hope you've been enjoying this legal week as much as I have. It is very refreshing to be able to get out of the office with the sole purpose of learning from practitioners like yourselves, and as I heard yesterday. Let me first express my deep gratitude to the Hong Kong Department of Justice and other organizers for this kind invitation extended to me to speak before you today. We at AIIB are very proud of the excellent cooperation we have maintained over the years on multiple levels with the Hong Kong government and particularly with the Hong Kong Department of Justice. I was asked to address the topic of good governance and high-quality development under international law. Good governance and high-quality development are essential for sustainable growth and prosperity of nations. To ensure that resources are managed efficiently, institutions are transparent and accountable under the rule of law is upheld. International law plays a crucial role in connecting, promoting, and safeguarding all these principles. Firstly, I believe it is important to unpack and describe the key elements of what governance means in the context of international development. As a conceptual framework, in my view, good governance ensures that decision-making processes are fair, inclusive, and responsive to the needs and aspirations of the people. International law provides a critical framework for promoting and protecting these principles through effectiveness and efficiency, which means good governance requires institutions to be efficient, and also that the agreements are established with standards and guidelines for governance practices. Good governance underpins the effective and responsible management of public and private institutions. It encompasses a set of key elements that contribute to transparency, accountability, participation, and the rule of law. Understanding and implementing these principles is crucial for promoting good governance practices. While one could come up with a long list, I have selected a few points that I'd like to share with you today. First, and in no particular priority order, transparency. Transparency refers to the openness and accessibility of information, decisions, and processes. It involves providing clear and timely information to the public, ensuring that decisions are made in a transparent manner, and promoting accountability. Transparent governance allows citizens to understand how decisions are made, how resources are allocated, and how public institutions operate. Second, accountability. Accountability is the obligation of individuals and institutions to take responsibility for their actions and decisions. It involves mechanisms for holding public officials and institutions accountable for their performance, ensuring that they act in the best interests of public. Accountability also includes financial accountability, performance accountability, and legal accountability, as it's obviously the knowledge of all the presents here. Third, something that Commissioner mentioned a few times in his speech today, the rule of law, which is very easy to perceive here in Hong Kong. The rule of law is the principle that all individuals and institutions are subject to and accountable before the law. It ensures that laws are applied equally and fairly and that legal frameworks are transparent and accessible. The rule of law provides a foundation for good governance by establishing a predictable and stable environment, protecting human rights, and promoting justice and fairness. The fourth one, effectiveness and efficiency. Good governance requires institutions to be effective and efficient in delivering services and achieving desired outcomes. It involves the proper management of resources, the use of evidence-based decision-making, and the implementation of sound policies and practice. Effective and efficient governance ensures that public and private institutions can meet the needs of the people and achieve their objectives. Fifth, and perhaps a very, very, very important one, ethical conduct. Ethical conduct is an essential element of good governance. It involves adhering to ethical principles such as integrity, honesty, and fairness. Ethical governance requires individuals and institutions to act in the best interest of the public, avoid conflict of interest, and maintain high standards of professionalism and integrity. These key elements provide a framework for responsible and effective governance in both public and private sectors. By embracing and implementing these elements, institutions can promote trust, legitimacy, and sustainable development, ultimately benefiting society as a whole. Under the vast but the just discussed solid principles of good governance, social and economic development can take hold and prosper, develop into high-quality development focusing on achieving sustainable and inclusive growth and benefit all members of society. It emphasizes the importance of economic, social, and environmental dimensions, ensuring that development is not only economically viable, but also socially just and environmentally sustainable. International law provides a framework for promoting and regulating development activities, ensuring that they adhere to principles such as human rights, environmental protection, and social and economic justice. At this point, I'd like to further illustrate this discussion by highlighting 3 points that play a vital role in the business that I come from, which is international development, which is promoting high-quality development under good governance and international law. Climate change, inequality, and the role of multilateral development banks, such as AIIB. Let me say that I could have selected many other themes, but in the interest of time, I focus on those 3. First, climate. A growing body of international environmental governance approaches codified under international treaties and the so-called soft law. International environmental law plays a crucial role in promoting sustainable development. It establishes principles and guidelines for the conservation and sustainable use of natural resources, the protection of our ecosystems, and the prevention of environmental degradation. Good governance practices such as effective environmental management and regulation are essential for achieving high-quality development that this is environmentally sustainable. Climate change and inequality are 2 interconnected global challenges that have significant implications for society and the environment, and they know no borders. Climate change refers to long-term shifts in weather patterns and temperatures primarily caused by human activities such as burning fossil fuel and deforestation. Inequality, on the other hand, refers to the unequal distribution of resources, opportunities, and power among individuals and communities. There are several ways in which climate change exacerbates existing inequalities. First one, disproportionate impact. Climate change affects different regions and communities in a very unequal way. Vulnerable populations such as low-income communities, indigenous peoples, and marginalized groups often bear the brunt of climate-related disasters, including extreme weather events, sea level rise, and food insecurity. Access to resources. Climate change can exacerbate resource scarcity, such as water and arable land, leading to competition and conflicts. Those who are already disadvantaged may face further challenges in accessing essential resources and existing inequalities. Economic disparities. Climate change can have adverse impact on economies, particularly in developing countries, heavily reliant on agriculture and natural resources. This can lead to economic downturns, job losses, and increased poverty, further widening the gap between the rich and the poor. Finally, health impacts. Climate change can have severe health consequences, including increased heat-related illnesses, spread of infectious diseases, and mental health issues. Vulnerable populations with limited access to health care and resources are more susceptible to these health risks, deepening existing health inequalities. Addressing climate change and inequalities require a comprehensive and integrated approach, and this includes mitigation efforts, reducing greenhouse gas emissions through transitioning to renewable energy sources, promoting energy efficiency, and adopting sustainable practices that can help mitigate climate change and the impacts that derives from that. This can also create job opportunities and promote economic growth. The very rapid growth that we see, for example, in China and solar panel is a testimony of that, adaptation. Adaptation measures. Implementing strategies to adapt to the changing climate, such as building resilient infrastructure, that is the business of AIIB, improving disaster preparedness, and enhancing social safety nets. Social justice and equity. Prioritizing social justice and equity in climate action is crucial. This involves ensuring the participation and representation of marginalized communities in the decision-making process, addressing historical injustices, and providing support and resources to those most affected by climate change. Finally, international cooperation. Climate change is a global issue, not a local one. It affects local, but it is a global issue. That requires collective actions. International cooperation through agreements like the Paris Agreement can facilitate collaboration, knowledge sharing, and financial support to address climate change and reduce inequalities. By addressing climate change and inequalities altogether, we can work towards a more sustainable and equitable future for all. Now, I'd like to address the interplay between inequality and international law. Inequality is a pressing global issue that affects individuals, communities, and nations, and we can see that rapid deterioration in inequality after the pandemic that we all suffered between 20 and 23. Inequality is a pressing issue. It refers to unequal distribution of resources, opportunities, and power among different groups of people. International law plays a crucial role in addressing and mitigating inequality by promoting principles of equality, non-discrimination, and social justice. International human rights law is a fundamental framework for addressing inequality. It recognizes the inherent dignity and equal rights of all individuals, regardless of their race, gender, nationality, or any other characteristics. Human rights treaties and conventions establish legal obligations for states to ensure equal treatment and non-discrimination. Furthermore, international labor law aims to protect workers' rights and promote fair and decent working conditions. It addresses issues such as discrimination, forced labor, child labor, and unequal pay. By establishing standards and guidelines for labor practices, public international law seeks to reduce inequality in the workplace and promote social justice. I also like to make a reference to international trade. International trade law has implications for inequality. While trade can contribute to economic growth and development, it can also exacerbate existing inequalities if not properly regulated. International trade agreements aim to promote fair and equitable trade practices, ensuring that all countries, particularly developing nations, have equal opportunities to participate in the global trade. By reducing trade barriers and promoting inclusive trade policies, international law seeks to address economic inequalities and promote balanced development. On this point, I can only lament the sorry state of WTO's dispute resolution mechanism, and only hope that this situation is addressed and solved soon. Additionally, international environmental law recognizes the disproportionate impact of environmental degradation on marginalized communities and vulnerable groups. It emphasizes the principle of environmental justice, which seeks to ensure that all individuals, regardless of their socioeconomic status, have equal access to clean and a healthy environment. By addressing environmental inequalities and promoting sustainable development, international law contributes to reducing disparities and promoting social equity. However, it is important to acknowledge that international law alone cannot fully address the issues of inequality. It requires the commitment and cooperation of states, civil society organizations, and individuals to implement and enforce these legal frameworks effectively. Efforts to combat inequality should also include comprehensive social and economic policies, poverty reduction strategies, and inclusive governance practices. Inequality is a complex and multifaceted issue that requires a comprehensive approach. International law provides a crucial framework for addressing and mitigating inequality by promoting principles of equality, non-discrimination, and social justice. By upholding human rights, labor rights, fair trade practices, and environmental justice, international law contributes to reducing disparities and promoting a more equitable and inclusive world. However, sustained efforts and collaboration at all levels are necessary to effectively tackle inequality and create a more justice and equal society. Now, throughout this presentation, I have presented several challenges. I'd like now to turn to the world and the role of multilateral development bank in addressing the governance issues discussed today. Multilateral development banks play a crucial role in developing and promoting good governance practice in their member countries. Good governance is essential for sustainable development as it ensures transparency, accountability, and effective decision-making. MDBs, as we call, such as the World Bank, the Asian Development Bank, African Development Bank, and the institution I represent, AIIB, have recognized the importance of good governance and have integrated it in its operations and policies. MDBs provide a financial resources, technical assistance to member countries for development projects and programs. To access these funds, countries are often required to meet certain governance criteria. MDBs assess the governance practices of countries and also companies, including transparency, accountability, and anti-corruption measures before approving projects. This incentivizes countries to improve their governance systems and promote the adoption of good governance practices. In addition, multilateral development banks actively engage in policy dialogue and capacity building activities with member countries. They provide technical expertise and guidance on various governance issues, such as public financial management, procurement, and regulatory frameworks. Through these interactions, MDBs can help countries develop and implement effective governance systems. Furthermore, MDBs support the development of legal and regulatory frameworks to promote that good governance. They assist countries in drafting and implementing laws and regulations that enhance transparency, combat corruption, and protect the rights of citizens. MDBs also provide support for the establishment and strengthening of institutions responsible for promoting good governance, such as anti-corruption commissions and ombudsman offices. MDBs also play a role in promoting regional and international cooperation on governance issues. They facilitate knowledge sharing and exchange of best practices among members, enabling them to learn from each other's experience. MDBs also collaborate with other international organizations such as the United Nations and regional development banks. Moreover, MDBs have their own governance standards and policies that guide their operations. They have established principles and guidelines for transparency and accountability and integrity in their own activities. Multilateral development banks play a significant role in developing and promoting good governance through their financial support, policy dialogue, and capacity building. They also contribute to the strengthening of governance institutions and the adoption of practices. By integrating good governance in their operations and policy, they promote the accountability that is needed for the projects they finance. While international law and international organizations cannot provide or dictate specific governance models, it provides a foundation of principles and standards that can guide states towards good governance. By adhering to international legal obligations, governments can promote transparency and accountability and sustainable development, ultimately contributing to the well-being of their citizens and the international community. Ladies and gentlemen, in conclusion, promoting good governance and high-quality development under international law is crucial for the sustainable growth and prosperity of nations. International law provides a legal framework for promoting transparency and accountability. It also establishes standards and guidelines for sustainable and inclusive development, ensuring that economic, social, and environmental dimensions are considered. By adhering to international law, states can foster an environment conducive to good governance and high-quality development, ultimately benefiting their citizens and global community. Again, let me thank the Hong Kong Department of Justice for their kind invitation and the audience for its patience, as I have attempted, hopefully somewhat successfully, to weave distinct but complementary issues under the framework of good governance. Thank you very much.
Thank you very much, Mr. Lineot, for your wonderful keynote remarks. Please kindly be seated. Thank you very much. So now we're going to proceed to our first panel discussions on interconnectivity of rules, the role of Hong Kong in the country's institutional opening up. So I would like to invite the moderator and panelists to come up on stage for this sessions, and please kindly be seated as indicated on the screen. So first, we'll be having our moderator, Mr. Roden Manlong Tong, President of the Law Society of Hong Kong, and our panelists including Dr. Anthony Neot, SC, JP, co-chairman of the Asian Academy of International Law. Ms. Peggy Aoyang Yu, Principal Government Counsel of the Legal Enhancement and Development Office, Department of Justice, the Government of the Hong Kong SAR, and also Mr. Philip Yang Liang Yi, Honorary Chairperson of the Hong Kong International Arbitration Center. So just a gentle reminder that there will be a Q&A sessions after the panel discussion. So if you have any questions for our moderator and panelists, please scan a QR code on the screen, on your table, or around this hall. And our moderator and panelists will address them accordingly. And now, without any further ado, I'm going to pass over the stage to Mr. Tong.
Good morning, everyone. First of all, I want to welcome everyone to this first panel of this session today. The topic is interconnectivity of rules, the role of Hong Kong in the country's institutional opening up. I'm very happy to join by a distinguished panel. In the order of presentation, I would first of all introduce Dr. Anthony Neot, SC. He's the co-chairman of the Asian Academy of International Law. Dr. Neot is a senior member of the Hong Kong Bar Association, specializing in international litigation, arbitration, and financial regulatory matters. Dr. Neot has served on a number of public office. He was a member of the Hong Kong Stock Exchange Council and its listing committee, and chaired its disciplinary committee and debt securities group, and was co-chairman of the legal committee of the Hong Kong and China listing working group. He was also the chairman of the Hong Kong Securities and Futures Commission. The second speaker is Ms. Peggy Aoyang. Peggy is the current principal government counsel in the Legal Enhancement and Development Office under the Secretary for Justice Office. She assists in taking forward the initiatives on strengthening the rule of law education, as well as the promotion and enhancement of the legal cooperation between Hong Kong and the mainland, in particular in relation to the construction of the Kong-Tong Hong Kong-Macau Greater Bay Area. Last, but certainly not least, we have Mr. Philip Yan. Philip has been a full-time international commercial arbitrator for over 30 years. He is the honorary chairperson of the Hong Kong International Arbitration Center. He is the member of the expert committee of China International Commercial Court of the Supreme People's Court of China. He also chairs the Shanghai International Arbitration Academy. Returning to the topic today, the role of Hong Kong in the country's institutional opening up. I would like to give a brief highlight of the resolution of the CPC Committee on further deepening reform comprehensively to advance Chinese modernization, which was adopted in the third plenary session of the 20 CPC Central Committee in July this year. The resolution outlined over 300 major reform measures with a focus on strengthening the rule of law in China, particularly in foreign-related affairs. The three contents of the resolutions related to Hong Kong include to reinforce and enhance Hong Kong's status as an international financial, shipping, and trade center, to support Hong Kong in building itself into an international hub for high-caliber talent, and to strengthen the work on the development of the Greater Bay Area, to enhance the systems related to lawyers, notarizations, arbitrations, and mediation, and to improve the arbitration and mediation system. With these three key elements in mind, I will now invite Dr. Anthony Neot, SC, who will give us an overview on the practice and experience on Hong Kong in connecting with high-standard international commercial and trade rules. Over to you, Dr. Neot.
Okay. Well, good morning, ladies and gentlemen, and it's very nice to see our good friends here, particularly Commissioner Tsui, Commissioner Fong, and Dr. Sun this morning. Now, I've been asked to talk about high standard international commercial and trade rules. Let me start with some history. Well, Hong Kong has always been a free port since 1841 when it first started. No custom duties were collected, although the Qing dynasty, in fact, had a customs collection station in Kowloon before it became part of Hong Kong in 1865. But after 1865, the Treaty of UK Treaty, which we consider to be unequal, was signed, and the Kowloon was then ceded. But then Kowloon, the customs station then moved to Kowloon Bay, which is not part of Kowloon at the time, and is next to the walled city, which was known then. But then the new territories was then leased to the British government in 1898. But then under the treaty, the customs station was still retained in Kowloon Bay. But unfortunately, Britain didn't really like that. And the Qing dynasty was very weak at the time. The British government then sent troops into Kowloon City and then basically asked the customs station and the officials of Qing dynasty to leave, and they did leave. I gave the year 1905 by memory, but actually I fact-checked that as wrong. It's actually 1899, 1 year after the lease. In fact, there was not a lot of patience on the part of the British government at the time. But since then, Hong Kong, since 1899, zero custom duties. We've always been a free port. Up to today, we are a free port. Now, but Hong Kong, of course, after the Second World War, became a very different creature. And Hong Kong has been the beneficiary of the international law and the international institutions which was created after the Second World War. That, of course, includes the UN, the World Trade Organization, the World Bank, the IMF, and so on and so forth. But in terms of trade, the most important agreement which Hong Kong benefited from was the General Agreement on Trade and Tariffs, which was the predecessor of the WTO. In fact, the Geneva meeting, which created the GATT, could not agree on setting up a WTO, so they decided on having an international convention. But that convention was very, very important for the growth of international trade. And you can see the statistics. Actually, so many tariffs were actually repealed really from the time of 1947 upwards, and really during the period of international trade all the way up to the end of the 20th century. In the beginning of the 21st century, a lot of tariffs were actually repealed. And we are now in a world basically with much, much less tariffs. There were some tariffs going on, but nonetheless, the tariffs did not destroy international trade. One of the important things that during the time of the early 50s up to now, Hong Kong experienced a tremendous growth in trade. One of the things that really created Hong Kong as an important export place was actually the US embargo when the Korean War started. The US embargo started in 1951 and did not end until 1970, actually, after the Nixon visit to China. So there's many, many years. Because of that, Hong Kong became a very, very important re-export place from other places into mainland China. And up to today, in fact, re-export from Hong Kong to the mainland represents more than 50% of the trade, of export trade in Hong Kong. In 2023, the export trade in Hong Kong was about 680 billion in US dollar terms. More than 52% of that is actually re-export from Hong Kong into mainland China. And only less than 49% actually are exports from Hong Kong to other countries. Now, the interesting thing about the exports to that is that during the 50s and the 60s and the 70s, Hong Kong became a very important light industry center. We were making things in Hong Kong, and we were exporting the things that we were making. Particularly, Hong Kong was making a lot of clothing, a lot of textiles. Because of that, Hong Kong, in fact, had to negotiate under an exception to the General Agreement on Trade and Tariffs called a multi-fiber agreement, which actually gave every country a set of quotas for export of clothing. to developed countries. And Hong Kong became very adept in negotiating these quotas and operating these quotas. The important thing about these quotas is this, is that you have to ensure that whatever is made in Hong Kong, is not made in other countries. And therefore, these rules are called rules of origin, which were very important and which lays the groundwork, in fact, for the next phase of development. We were so good at the MFA that later on, when the MFA was gone, and Hong Kong became a member of the GATT in 1986. The Hong Kong, of course, became a independent customs territory. Because of that, we joined the General Agreement on Trade and Tariffs in 1986, 1 year after the Sino-British joint declaration was signed. And that was basically the deal that China and Britain had, that Hong Kong, as an independent territory, can independently join the General Agreement on Trade and Tariffs in 1986. And because of that, Hong Kong became a founding member of the World Trade Organization when it was formed in 1995. So again, Hong Kong has a place in the international trading order. But that place, in fact, was really, I think, informed as well as, I think, assisted by the history that we had from the 1950s right all the way to 1995. The important thing is this. By 1995, Hong Kong is no longer a place that makes things. By 1995, Hong Kong's manufacturing industry was dwindling in 1995. And by now, today, let's look at today, from 1995, today, less than 1% of the goods that Hong Kong exports is actually made in Hong Kong. 99% are re-exports. Now that is well, you say that, well, in that case, what's made in Hong Kong? That's the question. Now, that's the question that, in fact, is asked, in fact, from the 80s onwards. Because from the 80s onwards, the supply chain of the world became global. Because you have one thing. Let's look at Apple, for example. Apple, that iPhone, is actually, a lot of that is made in China, but part of it is made in the USA. Some of the chips are made in the USA. It is manufactured in China. Some of the parts are made in India and so on. They get all sort of made into a phone by Foxconn in China. The question is, where is it made? Because many parts are made in various bits of the world. So which is why the WTO devised the rules of origin. Now these rules of origin, in fact, say this, is that in terms of a widget, something like this, the value of that is not just in the way it is made. The value of that comes from the intellectual property that goes into it, comes from the quality assurance that goes into the manufacturing, comes with, in fact, the way that it is operated through the global supply chain, and so on. Which is why a product, in fact, have rules of origin. And the rules of origin essentially say that in any place that has between 30 to 50% of the value of a product, that place can claim to be the place of origin of that product. Which is why Apple can claim, in fact, under the rules of origin, that Apple is actually a US product because it has a lot of. Now, Hong Kong, because of that, apply IP, intellectual property, in a lot of the goods that we have made in the mainland. They go into the quality assurance, they manage the goods. In fact, the branding of the goods essentially is a Hong Kong branding. As a result of that, Hong Kong, in fact, have its exports at the moment, 350 billion of its exports are still considered, in fact, Hong Kong exports. In fact, the reason is that more than 30% of that comes from Hong Kong. More than 30% of that comes from Hong Kong added value. The Hong Kong added value means that, the IP comes from Hong Kong, the design comes from Hong Kong, the knowledge that makes the product comes from Hong Kong, the supply chain management comes from Hong Kong, and so on and so forth. That's why Hong Kong still retains an important position in the international trade arena. Now, because of that, Hong Kong has been very much part of the rulemaking in the WTO. In fact, the original staff, executive staff at the WTO were Hong Kong trade officers, actually. And also, Hong Kong, of course, once, at some time, in fact, chaired the Executive Council of the WTO because of his membership. And of course, when China, in fact, acceded to the WTO, Hong Kong gave a great deal of help to the Commerce Department in order to do that. So again, Hong Kong has a lot of prime mover ability in terms of that. The other thing, moving away from the international trade law area, you have international customs, for example. Now, the international customs that we use in international trade are, say, Incoterms for trade financing in terms of the uniform customs of practice and so on. Now, all of these come from the International Chamber of Commerce. Now, Hong Kong is very, very much part of the rulemaking body of the International Chamber of Commerce. And in fact, at one time, the chairmanship of the International Chamber of Commerce was in Hong Kong. Dr. Victor Fung, in fact, was the chairman of the International Chamber of Commerce. And also the ICC, which is the International Chamber of Commerce, also is one of the most important arbitration courts in the world. It's the International Arbitration Court. And my co-chair, Ms. Teresa Chang, was formerly the deputy president of the International Court. So again, Hong Kong has a lot of say in these bodies. Not only that, but in terms of aviation and shipping, Hong Kong, of course, has its own register. But prior to that, Hong Kong has a great deal, even then, before 1997, Hong Kong has a great deal of autonomy in terms of that. Hong Kong negotiates its own air transport. This is air traffic agreements around the world. This is, Cathay Pacific going to London, how many trips, and the BA coming to Hong Kong, and so on, so all these trips and so on. Hong Kong has been traditionally negotiating that by itself, in fact, since, 1986. Prior to that, in fact, Hong Kong has to negotiate through the British government. Though I was a member of the administration up to 1980, I was at one stage involved in that, and Whitehall was very bad to us. And our financial secretary pushed back all the time. But nonetheless, since 1986, after the signing of the Sino-British Agreement, Hong Kong essentially got autonomy in air traffic agreements. Now, in addition to that, Hong Kong also has been very active in the international shipping arena. Now, BIMCO, which is the Baltic International Maritime Organization, was previously the Baltic Exchange, very important shipping conglomerate association around the world. In fact, the Baltic Exchange even started before the 19th century, right up to the Middle Ages with the Hanseatic Reed. Hong Kong now chairs BIMCO. In fact, one of the shipping companies in Hong Kong, the chairman chairs BIMCO, which is why, again, we are very, very much into the international trade rules. Now, let's come to the present day. The present day, we have gone one up in the present day. The reason why we've gone one up is that under the basic law, China has given Hong Kong its own shipping and aircraft register. Now, that actually is very, very important in terms of all kinds of financing around the world, because title is actually registered in Hong Kong. The second thing is that under Chapter 7 of the Basic Law, Hong Kong has much autonomy in commercial and trade affairs, and therefore very much involved in the international trade making. And even then, if we were not part of the organization in our own right, as Commissioner Trade this morning told you, that Hong Kong always attends as part of the PRC delegation and makes a true and important contribution in that respect. And which is why Hong Kong is the beneficiary of a lot of the World Trade Organization protocols, such as TRIPS, which is the protection of IP rights, TRIMS, which is the protection of investment, the TFA, which is the trade facilitation agreement. Hong Kong has one of the very best trade facilitation systems and IT systems in Hong Kong, in the world. And this is tied up with trade financing. And Hong Kong was very much part, through Dr. Victor Fung's efforts in the ICC's international efforts in tying up supply chain, tying up trade facilitation, and trade financing, all three tied up in one system. And that is what the ICC has done, again, through Hong Kong. Dr. Fung himself has been very, very much involved in that. If you were to invite him here today, he would last the whole day. He can talk about this the whole day. Now, so therefore, really, Hong Kong plays a very, very important part in international trade. And because of that, Hong Kong was able to really parlay a lot of its experience into its free trade agreements. Hong Kong has now many free trade agreements. Now, Alberto, my friend, just now said to you he's very, very sad about the dispute resolution system in the WTO. That is true. But the WTO rules are still very useful, and the ethos of those rules are now applied through many of the free trade agreements around the world. So that has what I would call a kind of a moral leadership, which is important, which actually infuses all the free trade agreements. And Hong Kong has been very, very much part of that. So we have many free trade agreements. The most important one, of course, is the one with ASEAN, and of course, with RCEP now coming up. So again, our sovereign country is helping us to join the RCEP, which will be important. So again, this is such an important area. Now, just one final word, which is that all of this, of course, is trade and commerce, but it also feeds into money. Basically, the financial aspect of trade is just as important. Now, I have no time to deal with that, but again, we have exactly the same, if not more, in fact, say in the international rulemaking and international intercourse in finance. The most important bit of this, of course, is that Hong Kong is very much part of the, through our central bank, part of the Financial Stability Board, which is part of the G20, an important organization. So we take part in a lot of the G20 discussions in terms of finance. Again, Hong Kong is at the forefront, and in fact, the BIS uses Hong Kong as their base for digital money in the world. And in the future will be digital money, and it starts from Hong Kong. Thank you.
Thank you, Dr. Liu, for an excellent overview on the history and the present-day interaction with the high-standard international commercial and trade rules. So may I now invite our next speaker, Ms. Peggy Aoyang. Peggy will tell us about the progress and prospects on the linkage of rules in the Greater Bay Area. Over to you, Peggy.
Thank you, Roden, for the kind introduction. And Commissioner Choi, Deputy Commissioner Fong, Dr. Sun, esteemed guests, ladies and gentlemen, good morning. It gives me great pleasure to join this very distinguished panel. Dr. Liu and Mr. Philip Yan, both very experienced legal practitioners in Hong Kong. And I'm very privileged to be with you today. The theme of this panel is connectivity of rules, the role of Hong Kong in contributing to the country's institutional opening up. On this, I would like to share with you the progress and the prospects of the linkage rules in the Greater Bay Area and how such connectivity would contribute to our country's institutional opening up. The term GBA, this reference, may be of very familiar to many of you, but it would still be worthwhile for me to perhaps just highlight some of the fundamentals. So, GBA comprises 2 special administrative regions of Hong Kong and Macau, and 9 cities in the Guangdong province, including Guangzhou, Shenzhen, Foshan, Dongguan, just to name 4 of them. On the extensive potential of the GBA, perhaps I will let the facts to speak to you. First of all, in terms of land area, the GBA is about 60% of Portugal and 43% of Greece. Secondly, in terms of population, GBA's total population is bigger than that of the UK, Italy, or South Africa. Turning to the money terms, GDP, GBA would rank ahead of Russia, South Korea, Spain, or Australia. If one is to compare the GDP's growth with other Bay Areas in the world, GBA enjoyed around 4 to 5% growth last year. San Francisco Bay Area around 3 or 4%, and Tokyo Bay Area 1.5. What is more important is that the GBA has a very unique legal landscape. Within one country, we have 2 systems and 3 jurisdictions, the mainland, Hong Kong, and Macau. In literal terms, the GBA is home to 3 legal systems. And I don't think this feature could be found in anywhere else within the world or any other Bay Areas. Therefore, against such legal landscape, which is so unique, and such enormous growth potential, what has the Department of Justice been doing to contribute to its development? In response to this 1, 2, 3 structural landscape, we have underpinned a guiding principle of 3, 2, 1 in our action plan on the construction rule of law promulgated by the Department of Justice in April this year. We aim to promote 3 interfaces, namely the interfaces of mechanisms, regulatory frameworks, and legal talents, in order to foster 2 connects, the connectivity of hardware and software in the construction of rule of law. And our eventual goal is to construct 1 GBA, strong and prosperous. While it is always good to have catchy phrases 1, 2, 3, or 3, 2, 1, we never forget to be pragmatic in transforming them into effective policy measures which are helpful to the legal and business sectors, the whole GBA, the country, and beyond. Allow me to focus on 2 aspects showing the latest development in the linkage of rules in the GBA. Firstly, the adoption of Hong Kong law and Hong Kong as the arbitration seat. Hong Kong is the only common law jurisdiction in China, and we have profound rule of law infrastructure. Our laws and dispute resolution services are highly compatible with those of the world. Investors, local and abroad, are often very familiar with our laws, rules, and services. We note that under the mainland law, the default legal position is that unless the contractual matter has met the requisite requirement of foreign elements, the matter would generally have to be subject to mainland law, and the relevant disputes be resolved before mainland courts or by the mainland arbitral institutions. At the moment, there is some flexibility for enterprises which are Hong Kong invested, but register in certain areas in the GBA to adopt Hong Kong law as the applicable law or choose Hong Kong as the arbitration seat. Such measures have a confined scope of application, the former in Shanghai, Shenzhen, the latter in the pilot free trade zones in the mainland. Let's first take a look at the implementation of the first measure of Hong Kong as the applicable law in the Shanghai court in Shenzhen. It's fair to say that the Shanghai court is one of the most forward-looking basic people's court in the mainland, and we're most grateful for its great contribution as the experimental platform in the past years. The Shanghai court has been the basic people's court handling the highest number of foreign-related or Hong Kong or Macau or Taiwan-related civil and commercial cases in recent years. Around 30% of its cases are such cases, and among them, close to 60% are Hong Kong related. And what is more, it is also the mainland court which has applied the Hong Kong law in the highest numbers of cases, amounting to a cumulative of over 130. In applying Hong Kong or foreign law in over 50 cases, the Shanghai court has engaged experts to assist in the proof of Hong Kong or foreign law, and in some cases, such experts have testified before the mainland courts. If you happen to like to hear more on this subject, I would invite you to join our Thursday morning session, in which there will be a thematic session sharing by experienced mainland judge, Hong Kong lawyers, and mainland lawyers who have first-hand experience on the topic. Going forward, our department is seeking to expand the scope of measures to cover more areas or other cities in the GBA. In this regard, we have very good news to share with you. Just last month, we have welcomed the amendments to the CEPA agreement on trade in services, in which the 2 measures are added as facilitation measures for Hong Kong enterprises. First of all, Hong Kong invested enterprises registered in pilot areas of the GBA may adopt Hong Kong law as the applicable law in their contracts, or Macau law. Secondly, Hong Kong invested enterprises registered in the 9 mainland GBA cities may choose Hong Kong or Macau as the seat of arbitration. The expansion of these measures will facilitate the internationalization of the business environment of the GBA, and more importantly, encourage mainland enterprises to use Hong Kong as the springboard to expand to overseas, and foreign investors to use Hong Kong as the gateway to the mainland. In the long run, we are seeing that Hong Kong's common law system will be contributing more in bridging the gaps and facilitating both onshore and offshore investments. This would be nothing but a strong testimony of how Hong Kong's unique advantages as a common law jurisdiction would contribute to the national high-quality development. Now let me turn to the second aspect of linkage rules in the GBA. It is the GBA mediation platform, a concerted effort of the legal departments of the Guangdong, Macau, and Hong Kong. Currently, 3 sets of unified rules or standards on mediation are in place in the GBA. The first set unifies the qualification requirements for GBA mediator accreditation. The second provides for a common professional code of conduct for mediators. And the last one is the model rules for mediation of cross-boundary disputes in the GBA. So what is Hong Kong's role in this? Hong Kong has proudly contributed to their drafting, in the process of which Hong Kong could be said to have exported our best practice and our experience. Let's consider the GBA mediator accreditation standards. When they were formulated, the prevailing accreditation requirements adopted by our homegrown Hong Kong Mediation Accreditation Association have been taken on board. In specific terms, work experience and case experience requirements, being standards adopted in Hong Kong, are featured in the GBA standards. The Code of Conduct and Model Mediation rules also feature various best practices in Hong Kong's mediation regime. For example, the Code of Conduct provides for the role of mediators in facilitating the parties in reaching consensus, and this is consistent with the primary practice of facilitative instead of evaluative mediation skills in Hong Kong. Both sets of rules prescribe for the use of caucus sessions as well, which are the procedures of holding respective and confidential meetings just between the mediator and each of the parties. This procedure is commonly adopted in Hong Kong's mediations and proved to be effective in facilitating candid dialogues so that the mediator could fully digest each of the parties' underlying concerns and hence help finding common grounds. While unification would be most helpful, the GBA mediation platform has at the same time taken into account the circumstances and operational needs of the 3 of the jurisdictions. For example, the relevant model rules would not prohibit a mediator, upon consent by the parties and where appropriate, to help evaluate the case and suggest options proactively. These specific roles, though not commonly adopted in Hong Kong's facilitative mediation model, would in fact pose no difficulties to Hong Kong's mediators, especially those who are legally trained. So looking ahead, having witnessed a very positive experience in the GBA mediation platform, what would be our next steps? I'll highlight 5 directions. Firstly, we are seeking to formulate a panel of GBA mediators by the end of this year. Secondly, we are turning to arbitration and working closely towards a set of common standards for setting up a panel of GBA arbitrators as well. With good rules in place, we need good talents to make good use of them. Hence, thirdly, we are supporting the latest initiatives of allowing access to civil and commercial cases filed in specific mainland courts in the GBA and the resolution of these cases through mediation by Hong Kong mediators. We warmly welcome such direct deployment of our legal talents by the mainland courts. And fourthly, still on talents, we attach great importance in building up a sustainable role and sustainable force of legal talents rooted in the GBA, serving the whole country and venturing beyond. The GBA enjoys a distinctive advantage of the presence of a group of special lawyers, the GBA lawyers. They're currently a team of 480 Hong Kong and Macau lawyers having the special qualification to practice mainland law. They themselves are the best ambassadors, channeling the interface of rules and practice within the GBA. The DOJ is advocating for a more structured brand building of GBA lawyers, facilitating them to contribute more to the country's continuing opening up. Going further, we are establishing a new institution, the Hong Kong International Legal Talents Training Academy, and you're most welcome to join its launch on Friday. This academy will organize practical legal courses, nurturing legal talents, and of course, international commercial arbitration and international commercial mediation will certainly be one of the subjects that the academy will touch upon. And lastly, bearing in mind the significance of adapting a mindset that embraces reforms and change, as specified by Commissioner in this morning's opening address, we endeavor to be innovative in the construction of the GBA as well. Apart from soft laws, like model mediation rules or model mediation arbitration laws, we would like to explore the need for and the feasibility of making unified laws and regulations in the GBA. So would topics like a common set of contract laws be worthwhile for our further studies? We would certainly welcome to hear more from you, the stakeholders and the experts too. To conclude, our work on connectivity of rules and talents in the GBA is always a work in progress, as it is a long-term strategy. At the same time, we're determined to bring you more and more deliverables in the not-too-distant future. So I'd like to wind up by sharing some thoughts on what principles will be of relevance to us in the days to come. Let me start with the G in the GBA. It stands for groundbreaking. I think we should not be afraid to do so, especially that the construction of GBA itself is the most innovative of all. For the B, I would say broad-minded. We should always be conscious of the bigger role GBA plays in the country's development and the potential it could bring on and beyond the country. And lastly, I would say agility. It is essential to be agile and adapt swiftly to the rapidly changing global landscape so that we could be proactive in leading the development in and out of the GBA. On this note, and with the groundbreaking spirit, a broad mind and an agile approach, I would like to work with you all in the construction of a prosperous GBA, unlocking its immense potential and contributing more to the national development and beyond. Thank you.
Thank you so much, Peggy, for sharing with us what the Department of Justice's action plan on the construction of the rule of law in the Greater Bay Area. So DOJ has really done a lot. So now, certainly not least, may I now invite Mr. Philip Yan to tell us a bit more on the Hong Kong's international arbitration regime in providing unique service to the country's institutional opening up. Over to you, Philip.
Okay. Ladies and gentlemen, thank you for inviting me to join this session. I would like to share with you, as a practitioner in arbitration, and the topic is Hong Kong international arbitration regime in providing the unique service to the country, institutional opening up. So I should turn to the first slide. Now, these are well-known mainland China policies and aspirations. I don't think I have to read them out, and it's all familiar to all of you. For example, the need to further strengthen international trade, one belt, one road, and play by the international laws and rules. And there is the omission of inadequate expertise in the mainland capable of handling international arbitration cases, which comes from the central government. And then, of course, it is important that China is already the second largest economy. Commissioner Choi has mentioned 18% of GDP. And I can say China, when it comes to international trade and shipping, maritime, it is in fact number one in the world. So that means a lot of contracts, a lot of disputes to resolve and so forth. This, I would say, all points to the importance of Hong Kong, which is the only common law jurisdiction in China. The uniqueness of Hong Kong, firstly, Hong Kong is the common law jurisdiction, and English law or common law is the de facto international law to international trade and commerce. Nowadays, in international trade and commerce, we look for guidance, we look for authority, we all look at common law. We don't look at any other law. And when I was young, more than 50 years ago, I still remember a time when I come across, for example, French or German standard form contract. I used to involve in standard form called Sino-Comex, French form, pointing to French law and so forth. Now, for the last 20, 30 years, I've never seen any other form other than English law form standard contracts. And Hong Kong, under one country, two system, we all know that Hong Kong follow the common law, follow English law. This has been reconfirmed again in the Hong Kong Court of Appeal case last year. Now, and Hong Kong is also a very important international arbitration hub in Asia. And remain receptive to the international commercial world. Historically, in fact, we are the first one in Asia. If you look at HKIAC, which I am the honorary chairman, we established ourselves in 1985 when globalization started. And SIEC, our nearest competitor in Asia, SIEC started 6 years later. Within that 6 years, I remember I went down to Singapore numerous times, 1 year at least 3 times, 2-3 times, just to teach arbitration. So we are having a head start in Asia in that sense. Of course, people can catch up, but the expertise remains in Hong Kong. That's important, some of the expertise. And Hong Kong has also built up a very comprehensive procedural law, case law, which is well known in the common law jurisdiction. It is often cited in English cases. I don't have the figures, but in Singapore, I come across a figure of 16%. In Singapore, court cases, when it comes to commerce and international arbitration, 16% of the cases, they rely or cited Hong Kong authorities. Now I come, after Hong Kong, I'm coming back to the difficulty China is facing to join the international world, commerce and law. And that is China has insufficient people, an experienced legal profession, which I've already touched upon. China has spent a lot of money in the last 30, 40 years to train expertise. It seems China has been very successful with science and technology from the very clear result that we all can see. But when it comes to law, it hasn't worked out very well. So it seems that the previous way of education will have to be reviewed. But unfortunately, we have the geopolitical tension. That means some of the better ways of acquiring international law, especially private law, is getting more difficult. For example, to study abroad and so forth. Of course, like everything else, whether it is chips, whether it is AI or EV or rocket science, China has to be self-reliant. And I think when it comes to this area of international law and international arbitration, China will have to go the same route. Now I come. I'm sorry, I've moved a little too fast. I skipped one PPT. Yes. Those are some of the difficulties which China are facing. But I'm not going to touch too much of them. I just say that when it comes to international arbitrations, China has a lot of thriving arbitral institutions, which we all know: CTAC, Beijing Arbitration Commission, Shenzhen Arbitration Commission, and so forth. And a lot of cases, a lot of arbitrators. But unfortunately, China arbitration law and practice is not an apple-to-apple comparison with international arbitration. The international arbitration that are being conducted in Hong Kong, Singapore, New York, London, or ICC. For example, which is very important, China has no known system of arbitration procedural law, because according to China's arbitration law, the administration of an arbitration is being delegated instead of going to the court, it has been delegated to the institution, to the different arbitral institution. And that, of course, by itself, it cannot establish a system of law, and no lessons can be learned from each other and so forth. And it is very difficult for foreign commercial parties to actually to feel safe or familiar to accept mainland arbitration. And that is the difficulty which is facing China. And go side by side with it, no matter how much experience you have practiced in China arbitration, they cannot actually grow international arbitrator. Now, I come to a very important point, which is currently being aware by some of the state enterprises in China, and that is the public policy. In China, the public policy of China, and of course UK, USA are becoming more adversarial and polarized, and the trend is not going to improve in the short term. Unfortunately, public policy and illegality is an unruly horse, as we all know that, and you never know which direction it is going. The list may get longer and longer until it can never end. So it will bring a lot of uncertainty, especially to medium or longer term commercial contracts. And as I said, China's state enterprises are starting to aware of it. Now, mainland China is the main user of English law and London arbitration, by far the main user of London maritime arbitration. Shipping arbitration is very important, and we all know the organization, which is called London Maritime Arbitrator Association, LMA. LMA rules, of course, has to be in English, but LMA rules has only one foreign language version, and that is Chinese. That means China users are very important to LMA. And for time to time, I've heard a figure of 50% of LMA cases came from China or China related. So that is the sort of figures of London arbitration. Now, why they use London English law and London arbitration? Of course, like everybody else in the world, confidence, and indeed London arbitration and English law has been doing very good services. And it also has to do with English law standard form contract, which I mentioned from the start. In Chinese domestic trade, they all use standard form contract. For example, shipping, they all use BIMCO contract. BIMCO contract, the default position is London. is London. And I have been the documentary committee vice chairman for 6 years, and in the documentary for over 35 years. So I know how the standard form contract has spread over the world when it comes to maritime and offshore industries. So a lot of standard contract, a lot of international trade, they use FNASPA standard form or phosphor standard form. Even in China domestic trade, for those reasons, as they are not cautious or alerted to the problem of public policy, they continue to use it, and they are sucked into the English law and London arbitration, and will be sucked into the public policy and illegality issue. Now that is starting to alert the Chinese, the mainland Chinese state enterprises. Therefore, if you want to source another common law jurisdiction, an arbitration seat, Hong Kong has to fit the bill. Now, again, this slide, I don't have to mention too much, other than the second part. Hong Kong, as I said, is a well-known international arbitration system because of its procedural law, amongst other things. I just cite one case, Sagang. Justice Hambron, now Law Hambron, said some nice things, but he is not certainly the only judge who said something like this about Hong Kong, but I just use it as a quotation here. And you can see Hong Kong is no doubt geographically convenient. It is also a well-known and respected arbitration forum with a reputation for neutrality, not least because of its supervising courts. Now, so I come to the last PPT, and that is the Hong Kong may be very crucial to overcome mainland's difficulty when it comes to international law and international arbitration. The first part has to do with education, common law education, which I won't say too much about it because of the time. And the second part of it is that we welcome, Hong Kong welcome, and in fact, I do see some very good people from mainland has actually coming to practice in Hong Kong, solicitor and barristers, and that is, I think, it's a very welcome thing to do. And now I come to the final part, which is in the commercial transactions. It will also facilitate mainland enterprises if they now start to focus themselves to depart. Even they continue to use the standard form contract, it doesn't matter. All is needed is to delete London arbitration and change it to Hong Kong. And Hong Kong is actually a very easy compromise for Chinese companies with foreign companies. They wouldn't like to go to mainland China's arbitral institution, but they can come to Hong Kong. And even with some of the Western countries, if Hong Kong is not acceptable to some of the Western countries, then perhaps a second compromise will be Singapore, at least to get away from the UK and US public policy problem. And finally, I'd like to say that just yesterday, I've heard a friend of mine, which is the chairman of a Hong Kong Maritime Arbitration Group, has accepted an appointment which is between Russia and Turkey. An appointment as arbitrator, as a sole arbitrator between Russia and Turkey. So those are the cases that Hong Kong will start to attract, and I hope it will go that way, and that will be Hong Kong's future when it comes to international law and international arbitration. Thank you very much.
Thank you so much, Philip, for your invaluable insight on the country's opening up of the arbitration regime for the international commercial disputes. Now, I think we are a little bit overrun on the time, but I do have some topical questions we'd like to ask the panelists. In particular, there's, as you know, that the US now is undergoing the US elections. So, Dr. Neil, so perhaps can you share with us what measure you think Hong Kong can take if the US government were to impose more sanctions to us, to Hong Kong?
Well, let me first of all say that Hong Kong, of course, is a free port. We don't impose tariffs of anybody, basically. And I don't think we're going to change that policy to start with. However, if you look at the US sanctions, on trade sanctions, forgetting the other sanctions on persons, because the person sanctions are a matter of sovereignty. It is a matter to be dealt with by our central government. Now, but as far as trade restrictions are concerned, we have, of course, a case whereby because of the so-called Hong Kong Democracy and Human Rights Act, Hong Kong is not considered to be as autonomous as it was in 1997 with the Hong Kong Policy Act. And that is the US interpretation, is not our interpretation, because autonomy is very clearly defined in the Basic Law. Now, but anyway, what has happened is that President Trump, before he ceased to be president, in fact, decided that Hong Kong does not have the autonomy, and therefore, Hong Kong-made goods, or Hong Kong goods which are exported from Hong Kong, made in China, should be labeled, in fact, made in China, not made in Hong Kong. Because prior to that, we do have this origination rules. If 30%, in fact, could be said to be Hong Kong-oriented, Hong Kong-connected, we still can say made in Hong Kong. Now we have to label made in China. However, our people actually add one other word. It's made in China, but originating from Hong Kong. Now, that is important because the US Customs has not, in fact, denied the 30% rule. In other words, if we're able to prove with a certificate of origin that 30% of the value of that goods originated from Hong Kong, the US Customs still does not extract added tariffs on those. So the US has been relatively sort of rational in terms of that. There is the kind of saber-rattling, high political statements and so on and so forth. But in terms of actual on-the-ground work, we have not been denied the 30% rule. So basically, goods originating from Hong Kong, which is why last year, 2023, our exports to China is 34 billion. Whereas the imports from the US is 27 billion. So we still have a lot of trade between our two places. The US, apart from mainland, which takes up 52% of our exports, 300 odd billion is to mainland, but 34 billion US. So there is a lot of common interest between the US and Hong Kong in terms of trade. So they don't want to destroy that. In fact, prior to that, sometimes imports to Hong Kong is more than exports to US. But it sort of varies from year to year. So essentially, what the US has done so far is to do a lot of sort of political statements. But in terms of actual work, they have not done to destroy their own position, which is why, despite the Democracy Act, the US did not, in fact, abrogate the air traffic agreements, did not abrogate the tax treaties, particularly did not abrogate, in fact, the Financial Account Tax Compliance Act, which is FATCA. All the banks in Hong Kong have to fill up FATCA forms in terms of US. So therefore, they're very, very careful in ensuring that, the common interests are still there, but allow, in fact, the politicians to say a lot of stuff.
Okay, thank you, Donna. So it looks like it's not too bad, right? Okay. So coming back to the Greater Bay Area. So Peggy, can you share with us what are the challenges in pursuing the interface of the rules and regulations in the Greater Bay Area?
Thank you, Roden, for the question. The challenges, yes, it is not an easy thing to have three legal systems in one country, and not an easy thing to make them work together, to collaborate with each other so that each of its own distinctive advantages could excel and contribute to the country and beyond. First thing, substantive law. Substantively, the laws of the different jurisdictions different. For example, we have different rules governing different aspects of civil and commercial, like marriages, divorce, and also the succession of property, so on and so forth. The second challenge is also could be seen in the way that legal procedures are conducted. For example, in Hong Kong, we practice the common law, and with the common law, we have the principle of adversarial system. It would be a party-led. So the parties will have say in how they conduct the cases. And they are, of course, in most high-end commercial cross-border cases, they will be assisted by our legal talents, the lawyers, barristers, and solicitors. In the mainland, it could be different. It's like more the court would have more role to the process. And what we are trying to overcome these challenges, we are building the gaps through our 3 connects, 2 connects, and a bridging of talents. We much like to help building a system that would facilitate the cross-border or cross-boundary resolution of disputes. So just to highlight one of the work in progress that would soon be promulgated is the service arrangements. So the system is again different. In Hong Kong, the parties serve the documents to the other side when they conduct the litigation. In the mainland, the court assists them. So it's again, you can see the challenges here. So we are trying to bridge the gaps. We are trying to give you all a version 2.0 service arrangement so that we would broaden up the scope of mode of services for Hong Kong parties to serve cross-boundary with the help of mainland courts. So we hope that with the concerted efforts in the room and beyond, with your intelligent in your contribution, we will bridge the gaps and overcome the challenges. And thank you once again.
Thank you, Becky. Thank you. So I'm sure, Becky, that with the joint efforts with the DOJ, the Law Society and the Bar Association and the Ministry of Foreign Affairs, we can overcome all the challenges. So last but certainly not least, Phillips. So one quick question. Any preference for the China-related contracts when it comes to dispute resolution? What's your view?
Do you mean China preference?
Yep, or your preference.
Yeah. My preference, of course, Hong Kong arbitration. I think the Hong Kong arbitration, we used to be, actually I don't mind, I sit a lot in London arbitration, especially before the COVID. And I'm not politically sensitive at all as a practitioner. But I understand in China, in fact, a state enterprise was concerned, and they actually talked to me, but they have already done that in an LNG, liquefied natural gas. They build a ship in China, and then they charter out and so forth. They start to feel worried about going to London arbitration with such a huge contract and so forth. And then they start to say, well, should we go Singapore or Hong Kong instead? And that was how it started, at least as far as my side of the knowledge is concerned. And now, of course, it become more, people talk about it now. And I understand people are still, of course, this type of knowledge you have to spread to a lot of commercial people. They are still using standard foreign contract. They are still receptive to London arbitration. And if they go to London arbitration, the problem is public policy. You'll be sucked into the public policy. You look at the New York Convention, it only, the New York Convention only concerned with regard to public policy in 2 places. One is the seat of the arbitration. The other one is the enforcement, the place of enforcement. Those two places will look at the public policy, and therefore it's not conducive to go to London anymore in that sense. So to me, it's logical to come to Hong Kong, or if some Western companies are concerned with Hong Kong, then Singapore is the second preference. That's how I think the trend is going. And we are talking about a huge market, China market, when it comes to GDP, economy, especially the activities in shipping and international trade. That means a lot of business is waiting to be tapped. Thank you.
Exactly. Thank you, Philip. And exactly, we are the top 3 IPO markets in the world anyway. Thank you very much, Philip. So I think our time is up. So can you join me in give a round of applause to our very distinguished panel? Thank you very much. Thank you.
Thank you very much, our moderator and panelists. Please remain seated. Please remain seated. And please look at our official photographer in the center for a group photos. All right, so please remain seated. Okay. 咁呢一張相我哋就一齊企起身影一張大合照啦，好嘛 ？Alright, so now our panelists and our moderator, please kindly look at our official photographer in the center for a good photo. Thank you very much for giving us a lot of your perspective and the role of Hong Kong in the country's institutional opening up. All right, so please remain on stage and please look at our official photographer for one more photo. Okay, a big round of applause for our moderator and panelists one more time. Thank you very much for your insightful sharing. So now, ladies and gentlemen, we are going to take a 15-minute break. So for those who are joining us on site, please enjoy the light refreshments right outside the hall. And for our online participants, please stay connected and I'll see you in 15 minutes. See you soon. Ladies and gentlemen, so welcome back to our second panel discussions on rule of law as a risk management mechanism to safeguard Hong Kong's and national sustainable development. So already on stage, we have our moderator, Mr. Victor Dawes, BPSSC Chairman of the Hong Kong Bar Association, and he's joined by three panelists in this session, including Professor Shen Wade from Ko Guang School of Law, Shanghai Jiao Tong University, Professor Ian Grenfell Cross, GBS-SC Honorary Professor, Faculty of Law, the University of Hong Kong. And also joining us online, we have Professor Liang Zheng, Vice Dean, Institute for AI International Governance, Tsinghua University. So same as the previous session, there will be a Q&A session after the panel discussion. So if you have any questions, please scan the QR code on the screen, on your table, or around this hall. And our moderator and speakers will address them accordingly. And now without any further ado, I'm going to pass over the stage to Mr. Dawes.
Thank you so much. Leah. Thank you. I was told that we are overrunning a bit, so I will, if you don't mind, get on with it because the speakers have been introduced and they are well known. So without further ado, can I invite an old friend of Hong Kong? I just got to know Professor Shan and find out that he worked in Hong Kong for 9 years before. So welcome back. And he will be talking about the interesting topic, new developments in financial sanctions and anti-sanctions. So Professor Shan, thank you very much.
Thank you. 各位专家
Dear experts, ladies and gentlemen, good morning. I'm so honored to be with you. I've listened to the previous panel. I got two takeaways. First of all, in the previous panel, the theme was business friendly. So I'm choosing something a bit more antagonistic, sanction and anti-sanction. And also previous panel, they have long time for speeches. I'm only given 10 minutes. Maybe that goes to show the one country, two system. So I try to be brief in my talk, given the assumption that you have some working understanding of financial sanctions. So I'm going to mainly talk about three issues. First of all, since the Ukrainian-Russian conflict, there has been an extreme sanction imposed to Russia by the US and the characterization, and also regarding the financial sanction from the US, what are the anti-sanction by the Russia and what inspiration? And thirdly, given the extreme pressure and sanction and anti-sanction, there was a tug of war and what is implication to China? Now, first of all, extreme sanction toward Russia since the Ukrainian conflict, the US, the West, is imposing extreme sanction toward Russia, which is categorized that Russia is the most sanctioned country in the world with over 20,000 sanctions against the country. And you can see on this map on the left, this is the US and the West with over 30 countries and regions imposing sanctions to Russia. In some of the unconventional countries are part of the game, like Switzerland. Those are proclaimed to be neutral country, which is unthinkable. And even Taiwan region of China is also part of the sanction. Singapore is also part of it. And also, if you look on the right, is clearly since the conflict in Ukraine, the number of Russian sanctions has grown to over 20,000. Before that, Russia was not the biggest sanctioned country target. It was Iran. Now, the extreme pressure is a broad range sanction. The traditional sanction include the military, political sanction, but there are two emerging interesting sanctions, which is the financial sanction. What I'm going to talk about today. The financial sanction is the main means targeting Russia and also the commercial sanction. What does it mean by commercial sanction? Many American, European companies, they will not require to take sanction against Russia For example, McDonald's, KFC, they have nothing to do with the war. They have nothing to do with high tech. They have nothing to do with military equipments. But they took proactive moves to withdraw and exit from Russia. Many companies did the same. European, French, luxury brands, they are out of Russia on their own volition. So this is the commercial sanction. The purpose of commercial sanction is like they want to claim the moral high ground toward Russia to be part of the extreme pressure on Russia. Among the sanctions, Russia companies, they are now in the sanction list. There are 9 sanction lists, and all the Russian names are there. And also, the American sanction to Russia is mostly focused on critical industries, for such the most competitive sectors: financial, military, defense, electronics, aviations. In financial sanction, the extreme measures include cutting off and kicking Russia out of SWIFT. That is, that's really a nuking Russia with the financial sanction. If economy was out of SWIFT system, that financial institution would not be able to trade in dollars. Now, SWIFT system is headquartered in Belgium. It is not exactly a sanction tool. If you're out of sanction, traditionally, it is not considered to be sanction or anti-sanction target. But what makes SWIFT special is in the way this is the necessary route for any financial institution to trade in dollars. If they're not in the system, they're not able to trade in dollars. And also among this sanction campaign, there was a new emerging feature, which is the Russia and U.S. both enter the crypto domain. For countries that are sanctioned or subject to sanction, the important way to counter sanction is for the money laundering. And the US side is targeting anti-money laundering. Like Russia, North Korea, many companies are using crypto, digital assets to launder the money to evade financial sanction. The US consider this is to be a new loophole to be plugged.
They have a very complex and large sanction system, can be categorized into 3. One is federal law, including international urgent economy right law, international emergency status law. So the parliament can take actions, and also including the executive order issued by White House, including the sanction on China of chips. It was also made by the White House. And thirdly is the rules and sanction list. And here we have financial sanctions laws, executive order, and their financial department's rules. So they take a lot. There's an office, OFAC, under the finance ministry. So they use this department to execute law. A lot of financial institutions in the United States become the sanctions, become the hand behind the sanction. Once in overseas, they touch the transaction target that are in the sanction list, they have the responsibility to report it to concerned departments. So they are also the shade or shadow execution body. In traditional sanctions, we use tariff or trade. So after the Sino-US trade war, the U.S. increased a lot of tariffs on Chinese products. That is trade sanctions, but financial sanction is not traditional. After September the 11th 9/11 incident, they think trade sanctions has a very high cost, and for themselves, they cannot tell the reason to their local companies about this transaction. It may interfere the sanction subject, especially terrorism or organizations. The most important way is to cut off their fund, so they launch the financial sanctions. The good point is the network is very tense, and for the sanctioned subject, for example, bin Laden, those terrorism organizations, is very effective to cut off their financial or capital flow. But for the countries that issued the sanction, they have a lot of challenges. It's different from the trade sanction. If you charge me 25% tariff, I can charge you back. But financial sanctions, they cannot fight back or take any anti-sanction ways because US dollar is dominated and the payment system for the entire financial and investment trade coverage is the largest. We always say RMB internationalization. However, nowadays the trade only accounts for 20%. For investment, it only counts for 2.2 something. So for the sanctioned country, they cannot take countermeasures. So one of the most or the largest character is unfair. So how did Russia fight back? So we can see first in a lot of the shopping malls in Russia, after the trade sanction, their shopping malls become empty. The Russia government also took a lot of measures in terms of the securitization of financial regulations. For example, the support to SMEs, the lending credit localization. They would like to set up an SFPT system that to replace SWIFT system using rupee as a currency, and they aim to the east. So Russia looks at BRICS countries, including China, for transactions. So their anti-sanction measures can be categorized into 4 parts. First is gas and natural gas. They packed it with rupee. So rupee has an anchor asset that is oil and natural gas, so as to ensure Russian rupee will not be depreciated to a large extent. And secondly, the foreign investment, they cannot leave the country easily, or they can state-own a lot of foreign countries. For some radical measures, for any enterprises or individuals that support U.S. sanctions, they will need to undertake the responsibilities under the civil war. And Russia also passed a lot of ways to do anti-sanction. So what are the implications? The largest implication is, of course, the comprehensive sanction measures on a measure. As Brunson said, they use China as worldwide extreme sanctions. We need to focus on from SWIFT system, they take them out of the SWIFT system. This is a risk. How can we take countermeasures? There are 2 ways. First is to be more aligned, symmetric. Whatever you take the way, you can fight back in the same way. So based on the asymmetric structure, we need to find the way that we can take. And of course, it's not financial sanctions or financial anti-sanctions. We can go into other sectors. And secondly, in the international system, we need to be prepared for the DPAC possibility. So you see the anti-sanction measures, including capital flow and capital market, is entirely separate them from the international financial system. And we focus on the infrastructure safety of financial systems and also diversify its financial system, meaning trading or transacting with non-West countries. And they launched a very clean local market, meaning the foreign enterprises cannot be into their local enterprises or system. So after the financial sanctions, they have their rupee settlement and payment system. China also set up CIPS system. So for the Europeans' payment system, they have already canceled it because they don't see it going any further. So sanction and anti-sanction, the largest effect is Russia's financial system is independent of the world financial system. For China, there are 6 implications. First is to increase our risk prevention capability. Second is resort to law. Thirdly, in terms of local law, we need to take into consideration anti-sanction. Fourthly is to set up the RMB internationalization payment system. Fifth is to de-dollarization, and sixth is to deepen the globalization and to opening up further. Thank you very much.
Informative, and those of us in Hong Kong, I think until a few years ago, we know very little about sanction and anti-sanction, but it is of course something that we are grappling with, and so that was most informative. Thank you so much, Professor Chang. So without further ado, given the time constraint, can I introduce someone who doesn't need introduction, Professor Grenfell Cross. He's going to talk about legislative trends on anti-interference in major Western countries. Thank you, Grenfell.
To go right. Which one? Where's that one? Okay. Thank you very much, Chairman. Good morning, Deputy Commissioner, ladies and gentlemen. I'm most grateful to the Office of the Commissioner and the Department of Justice for arranging this very successful event, and I'm most grateful that the Secretary for Justice has invited me to participate in today's discussions. As this is the second legal forum on interconnectivity and development, it obviously builds upon the foundations that were laid last year when there was a heavy focus on the rule of law in guiding the development of the Hong Kong SAR. And today's forum is, of course, multi-dimensional, and the way in which Hong Kong's national security arrangements protect its way of life from the menace of hostile foreign interference clearly deserves consideration, but it also requires a context. Now, on January the 10th, 2021, China unveiled its first 5-year plan for the construction of the rule of law. It was issued by the Communist Party of China's Central Committee, and it provides that the rule of law is a hallmark of the progress of human civilization, as well as the basic way of governance. Its objective was to overhaul the legal system and shape a distinctively Chinese socialist rule of law by 2025, with a view to its full completion by 2035. Now, the 5-year plan is also significant for Hong Kong, which was required to adhere to the rule of law and uphold both the Constitution and the Basic Law, which enshrines Hong Kong's common law system, as well as the legal rights and protections of residents. Also highlighted by the plan was the need to maintain the long-term prosperity and stability of Hong Kong, an integral part of which is to prevent and oppose the interference of external forces in Hong Kong. And shortly after that plan was promulgated, on March the 11th, 2021, the National People's Congress itself adopted the 14th 5-year plan for national economic and social development, and Hong Kong was again highlighted. It was required to safeguard national security, national sovereignty, security, and the nation's development interests, as well as its own social stability. Once again, the region was enjoined to resolutely prevent and curb interference by external forces in its affairs, and the message hit home. Hong Kong has now discharged in their entirety its national security obligations to the rest of the country, including the criminalization of external interference endangering national security. Now, it is recognized everywhere that when the national security of a country is endangered by foreign entities, remedial measures are legitimate. During the insurrection of 2019-20 and in the years immediately preceding it, Hong Kong's stability was threatened by hostile forces operating domestically in conjunction with foreign entities, and this endangered the survival of the one country, two systems paradigm. External interference by improper means, whether or not at the behest of local residents, is contrary to normal global practice, but let me be clear. When we talk about the criminalization of the act of bringing about an interference effect in Hong Kong, as the Safeguarding National Security Ordinance does, it must also be of a deleterious nature. We are not talking about genuine criticisms of government policies with a view to improving them, legitimate lobbying work, general policy research, normal exchanges with overseas organizations, or daily commercial activities. Those types of activities have always been acceptable in an international city like Hong Kong, and they remain so. However, what is objectionable is conduct that contravenes the principle of non-interference under international law, undermines national sovereignty and political independence, and poses a risk to national security. And this explains why the two 5-year plans which China unveiled in 2021 highlighted the need to counter the dangers that external forces can cause. The consequences of doing nothing and hoping for the best could have been dire, as was seen during the insurrection itself in 2019. And this is why effective national security laws need to contain an extraterritorial dimension, which is of great utility. They help to disabuse bad actors of the idea that they enjoy impunity when they use their foreign bases to try to harm another country and its people. When, therefore, the region enacted the Safeguarding National Security Ordinance on March the 3rd of this year, the importance of deterring foreign threats was recognized. It prohibits, through the use of improper means, collaboration with external forces to influence, for example, the formulation of policies or measures by the Central People's Government or the region's government, the discharge of powers and duties by the Legislative Council and the judiciary, or interference in local elections and related processes. Moreover, the offence of foreign interference endangering national security has been provided with extraterritorial effect, meaning the crime cannot be committed with impunity elsewhere by a local individual or entity. Now, when the policymakers were formulating the offence of foreign interference endangering national security, they did not operate in a vacuum. International models were examined, and they heavily influenced the final product. They included the National Security Legislation Amendment, Espionage and Amendment Act of 2018 of Australia, now incorporated into the country's Criminal Code Act of 1995. And its effect was to prescribe interference in Australia's affairs, and it did so comprehensively. The Australian amendment criminalised covert, deceptive and threatening activities by persons intending to interfere with Australia's governance and political systems or support the intelligence services of a foreign government. It also prescribed acts preparatory to foreign interference, and the law enforcement agencies were empowered to arrest suspects before the country's national security could be prejudiced, and the intended offence is still at the planning stage. The maximum penalty on conviction of intentional foreign interference is 20 years imprisonment, which is far tougher than the maximum sentence for the parallel offence in Hong Kong, which is 14 years imprisonment. However, ladies and gentlemen, it was the UK's foreign interference law which had the biggest impact on the safeguarding national security offence of external interference endangering national security. The UK's National Security Act of 2023 provides that if the offence is committed in a place outside the UK, the person responsible is prosecutable, and this is mirrored in the Hong Kong Ordinance. Although the terminology in the two instruments is not always identical, the objectives overlap. Although, for example, the UK's foreign interference law criminalises acts of what are called prohibited conduct, Hong Kong's law criminalises acts which have, quote, an interference effect. But they are basically the same thing, and both laws require a person to intend the impugned conduct to have an interference effect. Even the maximum sentence of 14 years imprisonment for both offences is identical. However, one notable difference is that whereas Hong Kong's external interference law requires a criminal intent, the UK's foreign interference law applies both a criminal intent and a lower test, and a person is prosecutable in the UK if he is simply reckless as to whether there will be an interference effect, which means that it's easier to prosecute a suspect. In Canada, the risk of external interference has also been recognized, and the law enforcement authorities have been strengthened accordingly. In June 2024, it modernized its toolkit and what is called an Act Respecting Countering Foreign Interference received the royal assent. It bolstered Canada's ability to detect, disrupt, and counter foreign interference threats by modernizing the existing laws. Whereas the Security of Information Act of Canada already criminalized information-related activities that were harmful to Canada, including spying, economic espionage, and foreign influence threats or violence, it has now acquired new foreign interference offences which cover deceptive or surreptitious acts that undermine democratic processes, including foreign interference in governmental functions and political processes. Also criminalised are deceptive and surreptitious acts that harm Canadian interests, such as facilitating the entry of foreign agents posing as tourists, and serious offences which benefit a foreign entity or are directed by such. Now, these reforms have been supplemented with extra powers for the Canadian Secret Intelligence Service. They include an enhanced capacity to collect and use data sets, new warrants to facilitate investigative techniques, and enabling the Canadian Security Intelligence Service to collect within Canada intelligence concerning the intentions and capabilities of foreign states and individuals in the country. And Canada has also intends to establish a foreign influence transparency registry, which will impose a registration obligation on particular individuals and entities with foreign connections. This will become operational on a date to be decided by the Governor in Council. And once it takes effect, those who enter into an arrangement with a foreign principal will need to register their arrangements and disclose any foreign influence activities undertaken if they are in relation to governmental or political processes in Canada, something that goes way beyond anything that exists here in Hong Kong. Now, although the United States has yet to enact foreign interference laws as elaborate as those of its Canadian neighbour, it would be wrong to assume it does not have ample tools available to it to counter what it perceives to be foreign interference in its affairs. Indeed, it was somewhat of a trailblazer in this area, and its Foreign Agents Registration Act of 1938, or FARA, is a very early example of a public disclosure law directed at agents of foreign principals who are engaged in political activities or other specified conduct. Such people are required to publicly disclose their relationships with the foreign principals, as well as the activities, receipts, and disbursements in support thereof. Moreover, the United States Congress is currently considering the Preventing Foreign Interference in American Elections Act, which seeks to beef up the controls which were originally adopted in 1971. If enacted, this piece of legislation would not only bar foreign nationals from directly or indirectly contributing to candidates and political groups, but also to groups that collect ballots, register votes, identify voters, or conduct efforts to mobilize electors. The proposed law seeks to ensure that malign foreign actors cannot directly or indirectly influence US politics and elections, and it echoes those which have been adopted elsewhere. And although not directly on point, it is perhaps worth mentioning that the US has deployed its extraterritorial jurisdiction to pursue foreigners whose activities elsewhere may have endangered its national interests, which is also a useful deterrence tool. It has achieved this by perfecting the protective principle, which enables a country to assume jurisdiction over acts committed elsewhere by individuals of whatever nationality that are considered to endanger its national interests. And in the US, the protective principle has been used against individuals outside its boundaries who have threatened its vital interests, including its security and governmental functions. Its scope is wide, and it has been directed at crimes against the security of the state, such as espionage, or against its money or credit, such as counterfeiting. The judiciary has said in the case of the US and Zia, 1985, that the protective principle enables a country to, quote, adopt laws that make it a crime to engage in an act that obstructs the function of government or threatens its security as a state without regard to where or by whom it is committed. Now, although the protective principle has been incorporated into Australia's foreign interference law and has been invoked in Canada for the offences of espionage and treason, the US has not felt it necessary to do likewise, at least not so far. Before concluding, ladies and gentlemen, let me say a little bit about Singapore. It is not only Hong Kong's regional neighbour, but it also shares a common law legal system inherited from the British colonial era. Like Hong Kong, it has recently introduced legislation to protect itself from external threats. In 2021, the Foreign Interference Countermeasures Act, known as FICA, was enacted, and its purpose is, quote, to protect the public interest by counteracting acts of foreign interference. The FICA strengthened Singapore's ability to prevent, detect, and disrupt foreign interference in its domestic policies, whether conducted through hostile information campaigns or through politically significant persons who could be local proxies. The FICA provides the Minister of Home Affairs with the authority to investigate individuals suspected of being foreign agents. There is also a new offence of what's called clandestine foreign interference by electronic communications activity. And the authorities can compel social media platforms and website operators to hand over data. And whereas acts of general interference are punishable with penalties of up to 7 years imprisonment, this rises to 14 years for acts of interference against a targeted person, which is the same maximum as in Hong Kong. So, ladies and gentlemen, once external interference laws are compared, it becomes apparent that Hong Kong's model is closely aligned to many of them, albeit not always as robust. As we saw in 2019, there are people who will stop at nothing to harm the region, but it is now able to defend itself from hostile interference in its affairs. This, I suggest, is a game changer, and it has been achieved in a way that reflects developments elsewhere. In consequence, Hong Kong is safer, its prospects are better, and its future is assured. Thank you very much indeed.
Thank you so much, Gwen, for excellent presentation as always, and very topical for us, given that the new legislation was only enacted earlier this year. Now, moving on swiftly, last but not least, of course, although he could only join us online, we have Professor Lang Zheng. He's going to talk about the recent developments in the global regulations and governance of artificial intelligence, something that we have also been grappling with. 梁老师，欢迎你。
好的，谢谢。
Okay, thank you, Chair. It's a pleasure to be with you today. I'm grateful for the Commission Office and Department of Justice for having me. I'm honored to be here with the Hong Kong practitioners and our colleagues to talk about something of a new phenomena, which is the international governance rules on AI, which is my topic. I'm from the Public Management School of Tsinghua University. I'm Vice Dean of the AI International Governance Institute of Tsinghua. So I have a few topics so I'd like to discuss with you. Can I move to the next slide? Yeah, first of all, I'm going to talk about the overall trend of the international governance rule for AI. And given that trend, we're going to talk about the multiple party, who's dominated the game in terms of cooperation for the purpose of competition, and some of the exploration on the key topics and key area for the rules for AI. And I will conclude with the outlook for the international governance rules for AI. So starting with the overall landscape of the international governance rules for AI, if I look at the specific contents of the rule setting, basically right now, the international law for AI, we are still at the early stage of forming such an international order of laws. In the UN reports, it was noted that the international organization headed by UN or other national actors, They are driving different form of solution for governance on different level, but we have not yet seen the emergence of a general international rule on AI, which is legally binding. So in terms of right now, if you look at the international domain, the AI governance rule is still predominantly principles, consensus, standards, ethical rules. Those are soft laws. There are some indirect governance rules, like international digital trade rules, cross-border data flows, and also against the cybercrime. But we still have scarcity in a direct international treaties, agreements, some of these hard laws that governs AI. And secondly, if you look at the participants, the multilateral process guided by UN is now driving the establishment of international rules for AI. Now, the dialogues, mechanisms across national actors are also playing their roles. International organizations, scientific consortiums, technology industry, they are actively participating in the rule setting. But still, given this domain, we are seeing a global competition on governance. Like the US and the West, they are, dividing camps based on ideology, and the developing countries are at a disadvantage in setting out these rules. So we are looking at the fragmentation and competition in terms of establishing rules. And thirdly, in terms of the contents of rules, the current rules are predominantly about ethics. Those are some of the main consensus, like how to prevent risks. This is something everybody is concerned with. But when it comes to specific area, in terms of how to form uniform rules, the progress, there is some progress, but there's still a massive blind spots. The existing international rules are not able to cover those areas, particularly when it comes to the ideology disagreement and even ethical and value differences. That also lead to more challenge in setting out a unified rules.
For cooperation, we think it's a character under the rule-making dominance. We are making the competition rules. From the multilateral progress, we take 2023 as a cutoff date. Our research entered a stage where we call global governance of AI. The transition and transfer from party process leadership to multilateral process leadership have emerged. We can see a multilateral dialogue negotiation. We are moving towards that direction. And under the United Nations framework, we launched a series of documents from Code of Ethics to some proposals by some nations to enhance the AI capabilities, reliability, etc. They were proposed by the United States and China. And also we launched a convention that is aimed to tackle cybercrime. We also have other documents, for example, future deeds or global digital compact declaration for future generations, etc. And also for Africa Union and ASEAN, they also launched some strategic guidelines in terms of AI. From country to countries, multilateral negotiation, there's a character led by the United States. There's a small circle under OMCD. GPI launched a joint declaration of founding members of the Global AI Partnership. and the AUKUS agreement among the United States, Britain, and Australia. And we also have other, most recent one is this September. US, European Union, and the UK signed the AI and Human Rights Democracy and the Rule of Law framework. We are still at the nascent stage, but you can see in the process there's a very noticeable trend that is led by the United States. We'd like to build the camp by ideology to make international rules, treaty, conventions. And the major countries play important roles and generates influential effects. As you can see, the European Union passed AI law. They'd like to be leading in terms of AI. And for the United States, they focus on AI development because of their leading strength and capability. Gradually, starting from last year, they pay attention to AI security and framework, formulation, etc. And for the United Kingdom, they emphasize on decentralization and multilateralism. They also launched some innovative regulatory framework, including hosting international convention and conferences to try to strike a consensus. Also for Singapore, they launched the first AI governance framework and operational guidelines to provide assessment tools to push forward AI governance practices. Singapore also played its supporting role as a third party. When we talk about multilateral actions and initiatives, we can see different countries, they have different strengths. And based on these strengths, they launched initiatives and rules, including legal rules. For China, we released a global AI governance initiative and inclusive plans for AI capacity building. We also submitted China's paper on regulating the military application of AI and China's position paper on strengthening ethical governance of AI. It's very comprehensive. And when we talk about the United States, United Kingdom, when it comes to military, and also including South Korea, the Netherlands, they are also making a lot of rules. Under such context, other than generic rules or regulations or guidelines, for some key issues and focus areas, we have some practices and theories, including data, computing, risk monitor, and risk prevention. But overall, it's still quite fragmented. There's no unified basic consensus focusing on AI development, security development. United Nations and China are pushing forward initiatives. And under multilateral framework, Singapore and DEPA, we are also pushing the digital partnership. And for data-related governance, we are also making rules focusing on AI development. How can we better utilize such a tool to serve society development? For security, including Argentina, Latin America, they proposed an additional protocol on certain conventional weapons for the development of lethal autonomous weapons. These are based on different topics we explored in those initiatives, targeting on these focus realm to mitigate the risk, to enhance the security, in terms of code of ethics. We even make more because it's not binding. A lot of the government, think tanks, industry, they launched a lot of AI code of ethics suggestions or proposals. Most of them are not law binding. But for some basic theories, they're overlapping by a large extent. Also, depending on culture's unique culture, national status, you can also find several differences. And for international industry association, when it comes to code of ethics and standard making, they play a very important role. We always take standards as soft law. So other than code of ethics, and also the rules made by some associations, we made the industry basic standards and the security regulations. And a lot of countries, including relevant security body, the NIST in the United States, or similar bodies in China, we also did a lot of work to set the framework. But the question is, we don't have a worldwide consensus regarding jargon, regarding the concept. So the interoperability is quite weak. Another thing that is worth mention is under China's leadership and with the support of Western countries, we are building up the AI capacity and we are setting up the AI Security Alliance. China also joined a lot of conferences regarding AI. And next year, there's another meeting in San Francisco, which China is going to join. So we are doing our very best to set up a standard, worldwide standard framework. So, based on what I have shared, we have multilateral cooperation and also the fragmented status quo. Going forward, if we would like to achieve a sustainable and healthy development of AI, we do need an international governance and law. Then how can we achieve it? We have several points. First is we need to reach a security consensus on the bottom line security, how we assess security level, and how can we categorize different risks. We need to reach a consensus. And also for some risks that we cannot control, we need to have backup plans. And based on that, how can we push the healthy development of AI? So on supply side, we need to have a certain space for the market. We need to be patient and to prevent overregulation. We also need to strike the consensus. We need to control, but we cannot over-control. Thirdly, under the UN framework, the bilateral or multilateral mechanism, they need to make sure that most of the stakeholders can participate fairly, including developing countries, leading countries, or countries that are lagging behind but have a strong demand in AI. So under AI framework, we need to set up a more open platform for dialogue and for mechanism setting. So that is our thoughts for the AI order and governance. That's pretty much of my sharing. Oh, last slide. For the AI, we need to have a bottom line for transparency, accountability, and people's common interest. We need to combat cyber crime. For these topics, each country can strike some laws and regulations through open dialogue. In short term, for example, we cannot strike consensus on development focuses or data. We can solve these discrepancies through soft law, through guidance. So every country can take discretion and to try to strike a consensus or explore the possibility that can have a convention or a framework to pave the way for the connectivity and inclusivity. And lastly, institutional synergy between international hard law and international soft law with the participation of multiple actors. We can have multiple parties to join together to form a worldwide standard system. I think Hong Kong can play a very important role in this. For example, on key matters, for example, finance, Hong Kong has a lot of experience and demands, and we can use AI to regulate or to provide public services for the international arena, and we can also give our full play to our position where East meet the West. We can push the international guidelines set up to support the AI development. So that's pretty much of my sharing. Thank you.
Thank you so much, 谢谢梁教授. Q&A session. The staff are really worried that I'm going to go off piece, but I'm going to do that and ask for some questions from the audience. The reason is I see Tony, and when we go to conferences, you usually have some questions on AI or sanction because those are the topic that really interests you. Tony, have you got anything you want to ask the speakers? If yes, can I ask the staff to pass Tony a mic because usually he comes up with really good ideas.
So we have questions from the audience. Could we have one of our colleagues please pass over the microphone to Peggy? Right. So can I please have one of our colleagues? Right.
Thank you, Mr. Moderator. It's been a very, very interesting panel. Thank you very much, everybody. There are really a number of questions, both in relation to sanctions and also in relation to AI. And you see, Grenville was talking about interference by foreign entities and how a country can protect themselves. Nowadays, we have very difficult geopolitical situations around the world right now. Now, the US at the moment, in terms of trade sanctions, it is really sanctioning every country, not just China, which is not friendly to the US, including Russia and so on and so forth, and Iran, not allowing them to use the highest possible military use chips. But at the same time, in fact, they are actually allowing other chips to go out. In fact, there's an exemption system in all the trade restrictions. And that exemption system seems to be quite well used. The question is, how do you think that the US can balance, in fact, their own interests? Because if they don't give exemptions, They don't give exemptions. People like Intel, Texas Instruments, and so on, they have to lay off the staff. So, that's not good for the US. The question then is, but then you need to balance that. What's the right balance? That's the question. The second question is in terms of AI. One of the really difficult things about AI is that it can be weaponized. And it can be weaponized, and in fact, it could be used, to destroy other countries. Now, in terms of weaponization, we have, of course, in international humanitarian law, the Geneva Convention. The Geneva Convention, in fact, disallows countries from using particular types of weapons. Things like cluster bombs at the moment is considered to be so bad, so destructive of humanity, that it is now outlawed by the Geneva Convention. In fact, the US doesn't use cluster bombs, but it sells it to other people, basically. And I don't know who, somebody's been using that, but it sells it. But anyhow, but it doesn't use it himself because it wants to abide by the Geneva Convention. My question is, in terms of AI, is it now the time to consider whether or not we should have a Geneva-type convention in terms of AI weaponization? The types of AI which should be so bad, so destructive of humanity, it should be outlawed by the international community. So 2 questions.
Thank you very much, Tony. Start with sanction.
Okay, thank you very much for the question, for a bunch of questions. I think we need to differentiate between sanctioning countries and sanctioned countries. Let's talk about US. Actually, US business community is strongly against the idea of sanctioning on chips and other advanced technologies, export control measures, so on and so forth. And there's a window in the sanction system giving the Samsung and other companies exemptions or waivers so that they can continue to export some less advanced chips to China. So that's about US. On the China side, we also need to differentiate between sanctioned institution and country. The Chinese government actually encourage financial institutions to comply with sanctions so that they can avoid bad consequence. The consequence can be devastating. For example, the worst scenario is sanctioned financial institutions can be kicked off from SWIFT system. So the advice is compliance. They need to take some precautionary measures and improve their compliance system. For example, they can bring in some sanction components in the compliance system. Let's have a database updating the list of sanctioned institutions. Financial institutions are advised to have a know your customer system so that they can avoid the financial sanctions as much as possible. As a matter of fact, there's an opposite strategy for financial sanctions. If you don't have a global business ambition, you don't have to be in the global system. So that some local financial institutions are actually focused on local currency, local business. They don't use US currency at all. They are not afraid of US sanctions. They can still keep relationship with North Korea companies and Russian companies. Thank you.
If I can just follow up, I mean, for Hong Kong, we have been hearing about sanctions because until a few years ago, it was not something that we were interested in. We were not affected by it. We are an international finance center, but we are in the thick of geopolitics. I mean, for a small jurisdiction like us with heavy economic activities, have you got any advice for our financial institutions, for our regulators, and for the small city in terms of dealing with this type of threats?
I think still we need to divide Chinese government from institutions in Hong Kong. The best advice for financial institutions in Hong Kong is to improve compliance system, to be away from financial sanctions as much as possible. But for Chinese government needs to prepare for the worst scenario. A large number of financial institutions are kicked off from the SWIFT system, like Russia. As a matter of fact, the US government is trying to experiment the financial sanction system to see what's the worst scenario for the US government if the massive financial sanctions are imposed on China, Russia, these large countries.
Thank you very much. Now, and over to Professor Leung. Tony's question about international humanitarian law. Should we regulate the use of AI now?
Okay, thank you so much for the question. This is a question that's very serious. I like to speak in Chinese. This is an excellent question. Actually, early on, between China and U.S., when the two countries are talking about the lethal weapon convention, under that framework of negotiation, we are talking about whether AI should be included into the management regimen. That was already part of the discussion. So previously, as I said, under the UN framework, like the Netherlands, Korea, in several occasions of the adoption of AI in military activities, the negotiations, it is also ongoing. There have been some consensus that are being made in that regard. So I think the basic consensus here is we believe for the out-of-control risk for AI, which might lead to some of the, in terms of research or in terms of making of international law, we believe the risks is pretty high. For example, it could be used for controlling of nuclear weapon. So the experts from China and US actually have consensus. So I think discussion on the international law level, this is going to be similar to the ban of biochemical weapon or the and also anti-nuclear proliferation. It's similar to those conventions. But what makes it complicated is that when it comes to adoption of AI in military use, we still have a question mark regarding the classification. AI is a broad-ranging concept. You can say robotics. Robotic can be considered to be like it could be encompassing software, algorithms. So how do you classify? It's kind of difficult to differentiate and classify. Like automated weapon itself, vis-a-vis the AI adoption in military, like the drones, the unmanned fighter jets. So those questions have not been resolved. So it is still unclear how huge the risk will be, what kind of consequences it will be. So here at Tsinghua University, we have a Center for Strategic Security, where we have 10 rounds of private discussion with the Brookings Institute. So we want to drive certain nomenclature, terminology consensus. We try to get some common ground, like in terms of nomenclature and classification. I fully agree what you mentioned, given the Geneva Convention. Now, when it comes to human safety in war or in some of the special circumstances, we need to protect and safeguard the basic safety of humankind. And we're not going to leave the destiny of humankind to something that's beyond our control. Or leave it to the automatic weapon system that is not in line with our own value system. And also in some of these details, we're looking at how can we make that distinction in some of the finer detail. That's what makes it complicated. So that process may still take a very long time before we can differentiate, negotiate, and also work out a solution. I try to answer your question, but this is a very complicated and very serious.
when we were dealing with the Article 23 legislation, I mean, we have all done the comparison, and you have picked out the ones that are most relevant and most up to date. But one of the criticisms that we often face is that, oh, if you're cherry picking particular provisions, a particular area, I mean, of course it looks fine, but you got to look at the law as a whole and the legal system as a whole. And it is said that, well, if you compare Hong Kong with some of these other jurisdictions, in terms of the package as a whole, we are really not up to it. They say their protection is better. Now, that is a common criticism. And what do you say about that?
Well, of course, as with all these things, it's a matter of getting the message out. The Commissioner made the point this morning that of the 5 connectivities, one of them is people-to-people exchanges. And obviously, through various means, we must explain our legal system, explain the similarities between our national security laws and those in other places, and indicate how our common law arrangements remain aligned to those of the rest of the common law world. Clearly, people who have bad views of Hong Kong are very unlikely to change their minds, but the vast majority of people, in my view, are relatively open-minded, and we must therefore take full advantage of the opportunities that we have to explain what the precise position is. We have a number of legal entities holding their conferences here in Hong Kong this year. The Law Society held a very useful conference in June, the Presidents of the Law Associations of Asia Summit, and I was able to address them and speak with quite a few of the people who attended. They were basically saying that, by and large, people in their own countries aren't too interested in Hong Kong's national security arrangements. But the people who actually attended the conference said, well, you know, we'd like to know a bit more about it. And having been told a bit more about it, they found that whatever concerns they had been allayed. And the Department of Justice, of course, is hosting the International Association of Prosecutors Conference this month, and I'm sure that some of the people attending that will also be interested in how our legal system works, and this will again be an invaluable opportunity for them to speak to practitioners and prosecutors firsthand, and indeed, if they have time, to go around the courts and see that our courts remain aligned to the common law system, and that we apply the standards that have always been applied here in Hong Kong. So it's a matter of getting the message out as best we can. There are some people who will always be indisposed towards us, but I think the broad mass of people are receptive to reason.
You have timed it perfectly, because I was just informed that we have ran out of time. So, ladies and gentlemen, can I ask you to put your hands together for our 3 excellent speakers? Thank you very much.
Thank you very much, our moderator and speakers. So Professor Liang, please kindly stay with us first. And then can I please invite the gentleman on stage? Let's have a good photos with Professor Liang. All right. So please kindly stand closer with each other. And Professor Liang, please look at the camera of your computer. So please kindly look at our official photographer in the center for a good photos. Thank you very much, our moderator and panelists, for your insight. Please kindly remain on stage. All right, a big round of applause for our moderator and panelists, and also thank you very much, Professor Liang, for your insight sharing. Thank you. Thank you very much. And now, ladies and gentlemen, to officially wrap up today's forum, it is my absolute honor to welcome the Honorable Paul Lam Ting Kwok, SPS SCJP, Secretary for Justice, Hong Kong Special Administrative Regions of the People's Republic of China, to come up on stage to deliver his closing remark. Ladies and gentlemen, let's welcome Mr. Lam.
Your Excellencies, distinguished guests, ladies and gentlemen, thank you very much again for participating in this year's 2nd Legal Forum on Interconnectivity and Development. I would first like to express my gratitude to the Commissioner's Office of China's Foreign Ministry in the Hong Kong SAR for co-organizing this forum with the Department of Justice of Hong Kong. OCMFA's support and contribution are invaluable to the success of this event. I would also like to extend my sincere thanks to the Asian Infrastructure Investment Bank, AIB, and especially to the General Counsel, Mr. Alberto Ninio, who delivered an impactful keynote address on the promotion of good governance and high-quality development under international earlier this morning. Hong Kong, China became a member of AIIB in 2017. Arrangement for secondment of DOJ counsel to the legal department of AIIB in the past few years has been conducive to enhancing our collaboration with AIIB and strengthening the development of Hong Kong international legal and dispute resolution services, especially in the financial fields. Following the keynote address from AIIB, the two panel sessions examined the critical importance of legal connectivity in our increasingly globalized landscape, as well as its impact across various fields, from international trade and commerce, dispute resolution, sanctions, to emerging domains such as the governance of artificial intelligence. The experience and practice of Hong Kong in conducting with high-standard international legal rules provide a good illustration for our discussion. Allow me to reflect briefly on today's discussion and Hong Kong's role in these vital developments. Legal connectivity transcends borders, bringing jurisdictions closer and promoting shared prosperity. As President Xi Jinping has noted, the fundamental purpose of advancing foreign-related rule of law is to better safeguard the interests of the country and the people, promote the progress of international rule of law, and the development of a community with a shared future for mankind. China's institutional opening up progresses alongside its development of foreign-related legal frameworks. The rule of law forms the foundation of a favorable business environment. The first session explored Hong Kong's evolving legal landscape, where under the One Country, Two Systems framework, it served as a strategic nexus for trade and commerce and dispute resolution, regionally in the Guangdong, Hong Kong, Macau Greater Bay Area, as well as internationally. In this era of ever-changing global business norms, as China's institutional opening up progresses, Hong Kong serves not only as a super connector, but also provides unique legal services under its legal international arbitration framework. On the importance of the rule of law to mitigate risks and to safeguard Hong Kong's and national sustainable development, the learned speakers have shared their insights into global developments in financial sanctions and anti-sanctions, as well as legislative trends on anti-interference in major Western countries. As artificial intelligence rapidly advances, it transforms industries and economies in a revolutionary way. It also brings with it complex global regulation and governance issues and related risks. As the final report on this subject by the United Nations Secretary General appointed panel concludes, and I quote, "The very nature of the technology itself, transboundary in structure and application, necessitates a global approach." The discussions on this topic today are timely and relevant as we consider how to safeguard sustainable development in an increasingly interconnected world with AI. As President Xi stressed during the 16th BRICS Summit, and I quote, "As the world becomes more turbulent, it's even more important to uphold the banner of peace, development, cooperation, and win-win outcomes." It's my sincere hope that discussions in today's forum could bring out a spirit of cooperation and collaboration in traditional fields like economy and trade, as well as emerging areas like artificial intelligence, with our sustainable development safeguarded by the rule of law. On cooperation and development, aligned with Hong Kong's development of 8 centers as outlined in the National 14th Five-Year Plan, the Department of Justice has taken forward policies to strengthen Hong Kong's role as a leading legal and dispute resolution hub. The staunch support of the Central People's Government in strengthening the city as a center for international legal and dispute resolution service in the Asia-Pacific region under National 14th Five-Year Plan can be demonstrated by the establishment of the International Organization for Mediation Preparatory Office last year. The IOMAC Preparatory Office has successfully facilitated the conclusion of the negotiation on the Convention on Establishment of the IOMAC last month. A decision has also been made by all the negotiating parties that a signing ceremony of the convention will be held in Hong Kong next year, and the IOMAC headquarters will also be situated in Hong Kong once the convention has entered into force. As the world's first intergovernmental international legal organization dedicated to resolving international disputes through mediation, IOMAC is important for the implementation of settling international dispute by peaceful means as set out in the United Nations Charter. Upon its establishment, the IOMAC will provide friendly, flexible, economical, and efficient mediation services, thereby building Hong Kong as a capital for international mediation. Apart from exciting development on IOMAC, we also continue to enhance our collaboration with prominent law-related international organizations, such as the International Institute for Unification of Private Law, the UNITRA, with which we organized this year's Asia-Pacific International Private Law Summit yesterday. We are also in active discussion with UNITRA for the possible establishment of its liaison office in Hong Kong in the near future. These forms of collaborations enable Hong Kong to contribute to and align with international standards, thus enhancing its appeal as a global hub for dispute resolution. In addition, with the support of Central People's Government and assistance of OCMFA, the Department of Justice has put in place programs to second local legal talents to several law-related international organizations, including the UNITRA. Through participating in the work of such international organizations, local legal professionals can enhance their knowledge of international legal matters and develop global vision. Nurturing Hong Kong's legal talents is crucial for the sustainable development of the legal community, for consolidating our position as a leading international legal and dispute resolution service center, and for the long-term development of the rule of law, matters to which the central authorities and the Hong Kong SAR government have attached great importance. Following the announcement in the Chief Executive 2024 Policy Address, the Hong Kong International Legal Talents Training Academy will be officially launched on this Friday, Day 5 of the Hong Kong Legal Week. To make good use of Hong Kong's bilingual common law system and international legal status, the Training Academy will regularly organize practical training courses, seminars, international exchange programs, and more to promote exchanges among talents in regions along the Belt and Road region. It will also provide training for talents in the practice of foreign-related legal affairs for the country and cultivate legal talents to be familiar with international law, common law, civil law, national legal systems, and other legal areas. In future, our department will make use of this capacity-building platform to enable practitioners from different jurisdictions to exchange ideas on promoting the culture of harmony. Looking to the future, we are reminded of the traditional Chinese saying by the Confucius. In Chinese, it's 君子和而不同. I think in English, a gentleman seeks harmony, not uniformity. This philosophy encourages us to pursue a shared vision despite our differences, and it's crucial for enhancing interconnectivity and development in building a community of shared future for mankind. In our interconnected world, such harmony through diversity is essential for achieving lasting success and mutual respect across boundaries. Hong Kong's dedicated efforts in aligning with and contributing to international legal standards, experience in international dispute resolution, as well as its commitment to legal capacity building could leave a positive impact as the world navigates through complex challenges. As China moves towards deeper institutional opening up, Hong Kong has a significant role to play in facilitating international engagement and promoting the progress of international rule of law. In closing, my sincere thanks to all speakers, participants, supporting organizations, colleagues at the OCMFA and the DOJ for making this forum a success. And I look forward to your support for the third Legal Forum on Interconnectivity and Development next year. Thank you very much.
Thank you very much, Secretary Lam, for your closing remarks to officially wrap up today's forum. Please be seated. Thank you very much. So, ladies and gentlemen, this concludes the second legal forum on interconnectivity and development.
Distinguished guests, the second legal forum on interconnectivity and development is successfully concluded. On behalf of the Commissioner of the Ministry of Foreign Affairs of the PRC in Hong Kong and the Hong Kong Department of Justice, we'd like to express our gratitude to all the officiating guests, speakers, facilitators, as well as all the participants joining online and offline. We also appreciate your feedback, so please scan the QR code in the hall or on the screen to fill in the survey. Please note that this QR code is different from the one in the Q&A session. Please scan the right code. As you're leaving, please make sure to bring all your personal belongings and remember to return the translation headset to the counter at the entrance. If you need CPD or ALE credits, you'll have to fill in the survey and check out at the reception desk. Thank you all again for your participation, and I look forward to seeing you again in other events of Hong Kong Legal Week 2024.
Yes, and we look forward to seeing you again in other events of Hong Kong Legal Week 2024. Have a wonderful day. Thank you very much.